He was my first supervisor.
Do we now have Justice Theron? I'll rely on you, please.
Justice Madlanga, all parties and judges are online.
Thank you very much. May the registrar clerk please call the matter.
Yes.
Good morning. I'm the Registrar Clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of National Education, Health and Allied Workers Union and Minister of Public Service and Administration and others, and SAD2 and others, and Department of Public Service and Administration and others, and Public Servants Association and others, and Minister of Public Service and Administration and others, and National Union of Public Service and Allied Workers and Minister of Public Service and Administration and others for hearing. Council are invited to place themselves on record.
No, it actually goes to YouTube now.
Or you put them online.
Yeah, there's a button I press here, it goes to YouTube.
Our blade environment was obviously
As the court pleases, Justice Madlanga and other justices.
All the judges are on.
My name
There's
is
two that go into the office, but they still
Justice
online.
Mr. Naidu, please mute yourself. Mr. Naidu, please mute yourself. Thank you. Thank you.
As the court pleases,
Yes,
Justice Madlanga and other justices of the court. My name is William Mukari. I appear for Nehau together with my learned junior, Mr. Masombuk. Thank you.
Thank you, Mr. Mukari.
Justice Madlanga presiding, other justices of the court.
Recording in progress.
May it please the court, I appear for the for SAD2, Pop Crew and Denosa, together with my learned friend, Mr. Salu Kazan.
Thank you, Mr. Maneche.
Justice Madlanga, other justices of the court, may it please you, I appear for the applicants in the matter 29/2021 with Mr. Whitcutt and Ms.
Thank you, Mr. O.
Justice Madlanga and other justices of the court, my name is Pedro van Wyk. I appear for the applicant together with my learned colleague, Advocate Komba, in the matter of case number 44/2021.
Thank you very much, Mr. van Wyk.
Justices of the Constitutional Court, good morning. Ms. Tobela Mkulisi and Ms. Richards appear with me, and we appear for the first and seventh respondents.
Thank you, Mr. Brainders. Thank you, Mr. Brainders.
Justices Jeremy Gauntlet with Frank Pelser appearing for the Minister of Finance, wherever he appears. Thank you.
Thank you, Mr. Gauntlet. Yes, Mr. Mukari.
Justice Madlanga, I am going to use the first 10 minutes, which has been allocated, which is the uninterrupted 10 minutes to outline the case for Nehau. But first, I would like to, for the benefit of the justices, identify where they will find the relevant page documents or pleadings insofar as they pertain to Nehau and the government. When I use the word government, I refer to collectively the National Treasury or the Minister of Finance, as well as the Minister of DPSA and DPSA as cited separately as a department. The relevant pleadings will be found from volume 13. Volume 13, you'll find the answering affidavit of Nihau at page 1326. That will be the first answering affidavit that was filed by Nihau, and the second answering affidavit is in volume 15, page 1497. The counter application to which Nihau was answering to, filed by the DPSA, is in volume 12, page 1183. National Treasury's answering affidavit, which encompassed also the counter application, is in volume 9, page 882. This will be the relevant pleadings as they presented themselves at the Labor Court, but subsequently elevated to the Labor Appeal Court upon request by the parties that the Labor Appeal Court determine the matter as court of first instance. The relevant pleadings which served before this court by way of leave to appeal will be in volume 16, page 1525, will be the leave to appeal that was filed by Nihau. The judgment of the Labor Appeal Court, which is the subject of the appeal or leave to appeal, is also in volume 16, page 1576. The impugned resolution, resolution 1 of 2018, which is the subject of the dispute, is found in volume 17, page 1706. In dealing with the matter, I propose to focus on 4 topics. The first, I'll deal with the binding nature of collective agreement, in particular, resolution 1 of 2018. The second topic, I'll deal with the invalidity argument as presented by the government respondents of resolution 1 of 2018. The third topic, I'll deal with the delay in launching the counter application by the state respondents or the government respondents. And the last topic, which is the fourth, I will deal with the discretionary powers that were exercised by the LAC when it granted the counter application, in order to demonstrate that the discretionary power exercised by the LAC was exercised in circumstances where it ought not to have exercised it in the manner in which it did. By way of introduction, that just for the benefit of the justices, but I'm aware that the history has been captured sufficiently in various papers and also in the judgment of the LAC, is that 2 parallel processes presented themselves before 2 fora when the state indicated that it has no intention to comply with clause 3.3 of resolution 1 of 2008 insofar as salary adjustments for financial year 2020-2021. Nihau, together with other majority unions, approached the PSCBC, the bargaining council, in terms of Section 33, capital A of the Labor Relations Act to enforce the resolution, particularly clause 3.3. The other unions which were not signatory to resolution 1 of 2018, like PSA, elected to approach the Labor Court directly for enforcement of the resolution, particularly clause 3.3. The state respondents opposed this matters both at the Labor Court and also at the Bargaining Council. The jurisdictional issue which was raised at the Bargaining Council was adjudicated in favor of the unions. The state respondents appealed or approached the Labor Court by way of an urgent application, which was unsuccessful. But later on, when the state respondents filed a counter application to the PSA Labor Court matter, the parties agreed that the arbitration which served before the Bargaining Council be postponed sine die, and the Labor Court matter be adjudicated by the LAC on an expedited basis. So that is how the other unions, the majority unions like NEHAU and SATU, became part of the litigation before the Labor Court or the Labor Appeal Court by way of an agreement between the parties that the matter be adjudicated there. But what we should mention upfront is that the participation of NEHAU in the Labor Court, Labor Appeal Court litigation was to oppose the counter application, but did not necessarily participate in the application brought by PSA, but it also did not oppose the relief that was sought by PSA before the Labor Court, because then that relief, if granted by the Labor Court, would also serve the members of NEHAU, and it will give effect to the complaint that NEHAU also raised about the government's refusal to implement clause 3.3 of the resolution. The matter was adjudicated by the Labor Appeal Court, sitting as court of first instance, and it delivered the judgment which is found in volume 16. As I've already indicated, that the judgment is in volume 16, page 1576. What is really the crux of the matter? According to NEHAU, the crux of the matter is that NEHAU contend that the Labor Relations Act was enacted to give effect to Section 23 of the Constitution to protect the interest of the workers. In doing so, it sought to ensure that in respect of collective bargaining, unions representing employees should come together and negotiate for any rights or even benefits that, according to unions, the employees who are their members are entitled to. Similarly, employers are also entitled, by way of organized employer organizations, to negotiate in favor of whatever they believe will serve the interest of employers. Government is represented in this type of negotiations by DPSA. DPSA negotiates.
Carry the 10 minutes is up.
Oh, thank you very much, Justice Madlanga. I'll be happy
to continue.
To receive any questions then from the justices. DPSA is the department that represents government in negotiations with organized labor. And this is to give effect to the right to fair labor practice in Section 23. So our submission is that whenever you interpret a collective agreement.
Sorry, Mr. Makare, if I may interrupt you. Two issues that concern me. The first is that I don't see any evidence of your reference to Section 23 appearing in the judgment of the Labor Appeal Court. Was it raised in the Labour Appeal Court this debate or this argument that you now present here under Section 23?
Yes, indeed, Justice Pillay. The starting point to Nehau was Section 23, which is giving effect to the right to fair labor practice. The reason, I suppose, and I can only speculate because I also read carefully the judgment of the Labour Appeal Court, why there is no reference to Section 23 of the Constitution, is because the approach of the Labour Appeal Court to the matter was a common law approach to contracts. So the Labour Appeal Court simply adopted the posture that a collective agreement is an agreement like any other agreement. And because it is an agreement where one party is a state, you must look at the empowering statutes which entitle the state to conclude such an agreement. And if those provisions have not been complied with, that agreement is invalid. So that's how then it looked at the matter. It was a common law approach, and then it looked at the state then as one of the parties, and then it simply then looked at the arguments raised by
the judgment starts with a quote from Lon Fuller, and it looks like the polycentric impact of the agreement or any judgment enforcing it seems to have weighed heavily in the mind of the court, because towards the conclusion of the judgment, polycentricity seems to weigh heavily. And the Labour Appeal Court talks about the impact of such a judgment on the greater population. Is that a wrong approach?
We submit that it was a wrong approach. In fact, the LAC started from the wrong footing when it quoted that passage to emphasize the polycentricity of the matter that served before it, when the starting point was supposed to have been, what is the effect of a collective agreement and what gives rise to a collective agreement? Had it asked that question, it will have realized that the starting point is actually Section 23 of the Constitution and not polycentricism. And you'll see, and I'm going to deal with it when I come to the discretionary exercise, that power that the LAC exercised. As you have correctly pointed out, Justice Pillay, it simply focused on then policy and polycentricism to say that we're living in difficult times, there is COVID here, there are people who are poor, and therefore they're not going to take money and give to civil servants who are having guarantees of their jobs when people have been retrenched in the private sector and all sorts of things. We think that that was a completely wrong approach, because it was bringing extraneous factors into a matter which is squarely regulated by the Constitution, which is Section 23, the right to bargaining, Section 31 of the LRA, which says that collective agreements are binding, and that was supposed to have been the starting point, and not the polycentric nature of the dispute that served before it, or as the LAC characterized it. And we submit that had the court then moved from the premise that first and foremost, when parties have negotiated, you'll see in the respective papers that there is a history of how negotiations were conducted. It was a to and fro type of a situation. Government going to take mandate, and when I say government, I'm referring to DPSA, going to take mandate from the executive, coming back with proposals, going back, coming back, the unions going to take mandates from their members, coming back. So it was that type of a process which happened.
I'm sorry to interrupt you, but on your argument regarding Section 23, can I understand what Nehau's position is? Is Nehau's position that Section 25(3) confers a right on trade unions to hold employers to unlawfully concluded collective agreements?
No, what we submit is that section 23 sub 5 is a bedrock of fair labor practice in the context of collective bargaining. That collective bargaining is something that happens as a product of thorough negotiations. And once the parties then put a pen to paper and sign, they've satisfied themselves that there's been compliance with all the requirements. We're not suggesting that it must, that the government must be bound to an unlawful agreement. In any event, then we're not considering that the agreement is illegal because we say that agreement has been given effect to for the past 2 financial years. That is 3.1 and 3.2 were complied with, and 3.3 is the one that is not being complied with, but we're not considering that it is illegal. But we're saying that the moment it was signed, then it was binding, and government stayed for 2 years implementing it, and only on the 3rd year, it came with a counter application to say that it is illegal. And but we're saying that there was nothing illegal with it, but even if it is found that it was invalid, we say that government could not be allowed to simply walk away, as this court has already pronounced in Gijima, because you look at the conduct of the party, you look at the wide powers that this court has under section 172 1B. So all those factors that have to be taken into account, it's not just a one-size-fits-all approach to say that, oh, well, then the agreement is illegal and therefore we must throw it into the dustbin, and employees who have earned a particular right of 3.3, which form part of their terms and conditions of employment, must simply be done away with like that. I submit that once
do I understand your argument to be because the government complied with its obligations for 2 years, that it is now stopped or waived from relying on the question of unlawfulness of the collective bargaining agreement?
What I'm saying is that the nature of the agreement that government concluded, which is a collective agreement, is no ordinary agreement like any other, is one that is governed by Labor Relations Act, because it is the Labor Relations Act which gave rise to that agreement. So once that agreement was concluded, the rights that accrue to employees became part and parcel of their terms and conditions of their employment. And if you want to take that right away, you have to follow the provisions of the Labor Relations Act. It is a dispute that falls squarely within the unfair labor practice and not a pure common law contract. So that's really then what I'm saying. So that's why I'm saying that the approach to the matter ought to have been first.
Mr. Makari, are you still with us?
Mr. Is obviously disconnected. Who do we talk to now? Isn't there a junior sitting with Mr. Mukari, perhaps, who has a device that's working?
Justice Madlanga, I'll try to give him a call and see whether they can come to his assistance quickly.
Please. Maybe let's just stay on, colleagues, and because it will be difficult to decide how long we adjourn for if we choose to adjourn. Yeah, we can get off video. Yeah. Oh, yes, Mr. Mukari. Mr. Mukari.
Yes, I don't know what happened. I just,
Yes.
I just saw my face being removed immediately. I'm sorry about that.
No problem, no problem.
Yes. So Justice Theron, in order for us to ask the right question, we must always locate the dispute within the Labor Relations Act. But if we remove it from the Labor Relations Act, then we're always going to ask the wrong questions. And the wrong questions.
Let me rephrase the question, Mr. Mukhari. If this court was to find that the collective agreement was unlawfully concluded or concluded in contravention of Regulation 78 and 79, in that event, what is NEHAW's argument?
So if the court finds that way, NEHAW's argument will then come into the remedy, section 172(1)(b), because the court will have invoked its powers in terms of 172(1)(a), which say that if the conduct is found to be unlawful, the court must declare it invalid. But what section 172(1)(a) does not say, it does not say that the court must declare it invalid and set it aside. So the missing part in that section is set it aside, because set it aside falls under 172(1)(b), and that's where the court will exercise its wide powers. So it is there when NEHAW says that even if this court agrees with the Labor Appeal Court that the agreement was invalid because it was concluded in contravention of Regulation 78 and 79 of the Public Service Regulations, and it is in conflict with Section 213 and 215 of the Constitution, that should not be the end of the matter. This court should then exercise its wide powers in 172(1)(b) by declining to set it aside. If it declines to set it aside, it will come with, or it will fashion a remedy that is just and equitable. And what will be just and equitable, according to NEHAW, is to look at the rights or the entitlement that is accrued to the employees already for the past 3 years, and to say that they should not be deprived of that, and it should follow exactly what it did in Gijimo. So that will be really what NEHAW will submit.
Mr. Mukhari, in your earlier responses, you referred to clause 3.3. That clause expired on 21 March 2021. Sorry, 31 March 2021. Is that correct?
The 3.3 was to give effect to salary increases for 2020-2021 up to 31 March. And so those salary adjustments ought to have been effected during that period. That did not happen, but it does not mean that that entitlement has fallen by the wayside. The entitlement still remains as long as it is found that government refused to implement unlawfully.
The Supreme Court of Appeal has found in City of Tshwane Metropolitan Municipality that specific performance is not possible once a contract has expired. What do you say to that?
Well, it depends on the facts, because I mean, it is fact specific. Where you seek specific performance in a form of rendering services, then it will not be possible because the contract is expired. So you can't render services to the contract that is expired. But if you seek specific performance by way of payment, that doesn't really then affected by friction of time. It still remains a debt. It still remains a debt to the one who was supposed to perform. It's a reciprocal duty. As we understand, the employees are not going to be given this as freebies. They will be given these salary increments quid pro quo for the services that they have to render. If they don't render the services, then they don't get then they don't get paid. But what we know is that these employees continue to render services, and they have rendered services. So it is now then the turn of the government to pay them. So this
Sorry,
is
I gave you the incorrect case reference. It's actually resultant finance. I'm sorry about that.
No, it's fine, but I'm saying, well, but my argument still remains the same than Justice Theron, that it is fact specific and context is also important. What is it that sought to be enforced? So here, what we're enforcing is payment. It's not rendering services. Services have already been rendered by our members. Our members have rendered services already. It is the government which has not performed its part. So it doesn't matter that the clause then came to an end on 31 March 2021. What remains is that the obligation doesn't go away. The obligation still remains that services were rendered by the employees and government must pay. So if this court finds that government refused to pay unlawfully, then it will not really excuse it from complying with that obligation. But I understand, of course, in other situations, specific performance may not be possible where a friction of time has taken effect.
If this court was to find that specific performance is not possible in this matter, would that render this matter moot?
If this court find that a specific performance is not possible, then it is the end of the matter, because then that is precisely what we want. We say that government must comply by paying. So if this court says specific performance is not possible, what it will be saying is that the state is not obliged to pay. So that's the end of the matter. So we don't even go to the mootness, because in order for this court to say that specific performance is not possible, then the government will say that there is no obligation on the state to pay. And that is the end of the matter.
Thank you, Justice Madlanga.
Thank you. You may continue, Mr. Mkari.
Thank you very much, Justice Madlanga.
Sorry, Mr. Mkari. Just to take up that response about specific performance in relation to payment, is that a defense when it comes to payment? Because it seems that if it is a defense, then every debtor who was unable to pay might be able to raise that defense.
Absolutely. I mean, I think you're absolutely correct, Justice Pillay, that a defense of inability to pay on affordability is not a defense in law. And we've actually said that in the limited instances that we are aware of is where then it is a temporary inability to pay that is raised, but not then as a defense that one cannot pay or unaffordability. And payment in particular is payment, and payment will always be payment for what has already happened. So one cannot claim future payments. So that's why then I also don't understand the issue of mootness in the context of payment, that it even arises. So absolutely then, I mean, say that you are spot on there, that one cannot raise it as a valid defense in law.
Mr. Mkari, can you please assist me here? You said in your responses to Justice Theron, you dispute that resolution 1 is invalid. Can you just expand on that, please?
Thank you, Justice Mhlantla. In fact, you came at the right time when I was going to my second topic, which is...
I might have a gap. I might have a gap, which is called Mhlantla in Xhosa, but I'm Chiki.
Oh, I thought it's Justice Mhlantla was talking. So is that
no, it's okay.
I'm sorry about that. I was trying to locate you on the screen where you're talking, but I seem to have seen Justice Mhlanhla's a microphone unmuted, that I thought that she was the one who was talking, but I'm sorry about that, Justice Chiki. Yes, I'm saying that you actually asked the question at an opportune time when I was about to start dealing with the second topic of the invalidity of the agreement. And we are aware that the state respondents locate the invalidity squarely within non-compliance with Regulation 79, right, with Regulation 78 of the Public Service Regulations. Our submission in that regard is a brief one. The regulation has been reproduced in the Labor Court judgment, so it's better for us to look at it so that we don't have to look at many documents than at once. You'll find it at page 1581, volume 16. So let me read it to see where the non-compliance arises. Collective bargaining shall be regulated by the LRA. The executive authority may enter into a collective agreement on a matter of mutual interest only if that authority is responsible for managing collective bargaining on behalf of the state as employee in that forum, has authority to deal with the matter concerned, and meets the fiscal requirements contained in Regulation 79. In the public service.
Excuse me, Mr. Kari.
Yes.
My understanding of the nub of the challenge is Regulation 79. Yes, there's reference to 78, but it seems to me the nub of the challenge on invalidity is Regulation 79, and it is based on the letters that were written by the ministers of finance.
Yes, yes, I think that's the letter of 18 February 2018 from former Minister Gigaba, and that is the letter that the LSC relied on it heavily. But the relevance of Regulation 78, I think, is C. You see 2C there, which says meets the fiscal requirements contained in Regulation 79. So then it refers you to Regulation 79. And then you then look at what are the fiscal requirements that are to be met in Regulation 79. What has been said is that the collective agreement, if it has financial implications, then the money must have been budgeted by the same department. In this case, it will be DPSA, or then other departments must have committed themselves that in terms of their share of their financial burden. And also, if then they are not, National Treasury must have also made a commitment. So that's really the nub of Regulation 79. And what the state respondents are saying is that that did not happen. So then that's what they tell us. But it is not what they tell us that matters, Justice Chikwe, but it is what objectively happened. So then we have to look at objectively what actually happened. Objectively, then what we see happened is that Cabinet approved the proposal that was put forward by DPSA to the unions. And that proposal, before its approval by Cabinet, it is one presented to Cabinet by the same Minister of Finance. But the technical argument that has been raised and accepted by the LAC, and we submit that was incorrect, is that it doesn't matter that Cabinet, it doesn't matter that the Minister of Finance then tabled the proposal to Cabinet, and it doesn't matter that Cabinet approved, but what matters is that there is an absence of an actual written commitment by the Minister of Finance. Our submission is that that is over technical, Justice Chikwe, because one has to look at the responsibilities and duties of Cabinet in terms of Section 91 of the Constitution. It is the highest making decision body where even the Minister of Finance then sits. So one is to look at it in a proper context, just the same as we interpret the legal instruments. We don't interpret them in isolation, but we must interpret legal instruments within the context in which they arose. So even here, one has to understand the context in which then the entire thing arose. It arose in the context where there were negotiations between government and unions about salary adjustments or increments over a 3-year period. And that government ultimately, with its highest making decision body, approved that this is the proposal that government must put before the unions. So we submit that there was an approval and therefore there was compliance with Regulation 79. Of course, then we do not see any letter.
Mr. Mkari, sorry, no, I get your argument. I mean, I read your case. You make exactly that point. I looked at section 216 of the Constitution, which seems to give National Treasury its own distinct existence. Does that, what is the effect of that on what you are arguing now? Does it mean that National Treasury, which has a distinct existence, can be overruled by cabinet decisions?
No, well, we're not suggesting that. What we say is that National Treasury was never overruled. We're saying that there is no evidence that National Treasury put any countervailing evidence before the executive, which was overruled. But the evidence that seemed to be there objectively is that the matter was discussed by cabinet at the instance of National Treasury. So it was the duty of National Treasury, or at least the deponent to the affidavit, that's the DG of National Treasury, Mkhajan, who deposed to the affidavit, to say to the court, and of course we say in our papers that all departments, DGs, were participating in these negotiations, and understandably so, because I mean, negotiations about salary increases carry financial implications. So you'll assume, I mean, you'll imagine that the highest decision makers then will be present there. So the DG of Treasury also is there present. So he doesn't say in the affidavit that National Treasury raised its discomfort about these increases, unavailability of money and affordability. It doesn't say that. It doesn't say that the proposal put forward to cabinet by National Treasury or the Minister of Finance was actually jettisoned by cabinet. It doesn't say that. So this has to be read in a particular, then it has to be read in a particular context, that at best what happened is that after deliberations by cabinet, a decision was taken that go put DPSA, go put this proposal to the unions. The proposal was put to the unions took mandate from members, and the unions came back and accepted the proposal. So this is not the other way around, where unions put a proposal and government accepted it, where you'll say that DPSA simply accepted a proposal from unions without any mandate from cabinet or without commitment from National Treasury. But it was the other way around, where it is the government itself which put a proposal to unions and unions accepted that proposal. So we submit that it is really completely unacceptable that National Treasury will then come at the late stage now to say that I didn't put any commitment. See the letter of former Minister Gigaba. There was no commitment and therefore there was non-compliance with Regulation 78. In fact, then to exonerate government then from complying with obligations which are binding on such then explanations, it will really set the wrong precedence. Section 216, if you look at it, it does not call, sorry to
stop you mid-sentence, Mr. Mukari. The 40 minutes is up. How much more time do you want?
Oh, I was not aware that it is up. Then may I just ask for between 5 and 10 minutes so that I can just round up.
I'll give you 10.
The delay in discretion.
I'll give you 10.
Oh, thank you very much, then, Justice Madlanga. But let me just start then. I mean, the question that Justice Chikti then asked me in the context of Section 216 of the Constitution about Treasury control. So you'll see, Justice Chikti, that 216 simply deals with Treasury control, but then yet it might just be right with Section 91 of the Constitution, which deals with, well, I mean, when you look at 91, it then tells you about cabinet, then it tells you cabinet, and 92 about then accountability and responsibilities. So the two must be read together. And our submission is that cabinet is the highest decision-making body and recognized by the Constitution also as distinct, the same way as National Treasury is been recognized by the Constitution as distinct in 2016. But there, it is all about then the controls, financial controls. So we say that there was compliance with section, with Regulation 78 and Regulation 79. But just to
Mr. Mukari, putting aside for a moment the point you make about cabinet, you referred to objective facts. I just want to understand juristically where you peg your argument around those objective facts. Is it a substantial compliance argument or is it something else?
It will fall under substantial compliance in the light of the absence of the actual letter from National Treasury, which makes a commitment, because it seems like there is no such letter. But we say that on objective facts, this court will find that there was substantial compliance, yes. Thank you, Justice Madlanga. Let me quickly then just round up the issue of a delay. Well, insofar as delay is concerned, it has been raised pertinently by...
Mr. Mukari, I'm sorry
is that Justice Madonda?
There's something we have to clear up here. Madonda, yes, correct. That's correct. Do you hear me? Do you hear me now?
Yes, I can hear you, but you're blaring than before, but now you are okay.
Okay. Apparently from the papers, clause 3.3 was somehow asked. Am I correct?
It was somehow what?
Isolated.
Yes.
It was treated differently.
Yes.
From the 3.1 and 3.2.
Yes.
And the statement by the Minister of Public Service and Administration is that the understanding between the government and the trade unions was that the clause 3.3 was that the government will only was that there was no money approved by the parliament for the implementation of clause 3.3, and that the government will only make its application in terms of the clause if certain cost-cutting measures were implemented. What do you say to
that? Thank you, Justice Madonda. Well, I think that was the letter of former Minister Gigaba. That's what it was saying. But it was not saying it in the context of 3.3. Insofar as 3.3 is concerned, the enforcement is as it is signed by the parties and as it is written in the resolution itself. The letter of Gigaba then came before the signing, because the signing came a little later, somewhere in June of that year. But all what was saying is that the 3-year term, in order to conclude the collective agreement, rather initially government wanted a 4-year period, then for the conclusion of the collective agreement, and unions proposed 3, and then government came with that proposal of 3. So, so then 3.3 must be understood in the context of government being satisfied that it will be able to raise the money. And then if then government comes later that can't raise the money, then that is a different issue. It's not invalidity, that one.
No, the minister says there was no problem for the implementation of 3.1 and 3.2, but there was a problem for 3.3 because the cost of its implementation will exceed the compensation envelope. It was against that background the Minister of Finance proposed that can be covered by putting cost-cutting measures in place.
Yes, I understand that. I understand. I mean, like retrenchments, voluntary retrenchments.
Yes, that shows that move by the Parliament for the implementation of 3.3. Is that so?
Well, just Madonna, well, I battled to hear you then in certain instances, but I did get the crux, then the crux of your question. Yes, well, I mean, like I've said, if you're referring to Minister Gigaba, he spoke before the signing. If you're referring to the Minister of DPSA, then DPSA then speaks ex post facto. But we're talking about at the time when the agreement was concluded. So at the time when it was concluded, government was satisfied that it will meet its commitments. So then that's really then our answer. Ex post facto explanations by DPSA, we submit that they remain what they are, ex post facto. And then what Minister Gigaba said initially, then before the signing, he was simply proposing that there may be other ways in which we can still ensure that we sign an agreement with the unions by making sure that we encourage voluntary retrenchments, we encourage departments not to pay performance bonuses which exceed 2 billion rands, that we can reduce that to below 1 billion. So he was really coming with all sorts of proposals. But what we do know is that in the end, the government actually put a proposal. So that to us then is quite material.
So what was the need of that proposal by the Minister of Finance if the money was available to cover 3.3?
No, he was putting proposals of how government can mitigate other financial strains that may come with the increases that are contemplated. But what I'm saying is that when people negotiate, they put proposals one way or the other. But what matters is no longer what proposals that they were putting. What matters is that ultimately a final proposal which was accepted was put by government. And that to us then is quite material, and that's the crux. A lot of proposals were put forward, but those proposals then don't translate to an agreement, because the agreement is the one that ultimately is accepted by both parties, offer and acceptance. So there was an offer by government, and then there was an acceptance by unions. And that gave rise to what is called Resolution 1 of 2018. Okay, thank you, Mr. Madlang.
And the government, sorry, and the government says that that proposals were not sanctioned by the provisions of Regulation 79 because there was no money approved by the Parliament at the time. So it was then done in contravention of those.
Yes, yes, we're aware of those. They were aware of those submissions by government that they are saying that they've breached the law. So that's what they're trying to tell us. Then they're telling us then 3 years later. So that's what then they're telling us. So then they actually then deliberately breached the law. So that's what they're saying. But we're saying that objective facts are actually against them. That they didn't break any law.
When did you become aware of this?
Mr. Mukari, the 10 minutes is up, but I know throughout the 10 minutes I said I was giving you, my brother Justice Matondo was engaging you. So maybe let's see when Justice Matondo is done, what we can do about you addressing the question of the delay and the discretion. Continue, my brother.
Actually, I accept that Justice Matondo has taken my 10 minutes, so I'll use only 2 minutes from it.
Thank you. Yes, just continue, my brother, Justice Matondo.
So, when did the unions know for the first time that there was no money approved for the implementation of clause 3.3?
Yes, no, yeah, like I said, just Madonna, that your line is not really one of the best. That's a problem, yeah.
Are you not in a position to respond to the last question, Mr. Mukari?
No, I could not even hear. I could not even hear the question.
Please,
if you can repeat
please
it for me.
repeat your question, Justice Matondo.
Okay. When did the trade unions know for the first time that there was no money approved by the parliament for the implementation of clause 3.3?
Yes, your first part then was cutting.
Can I assist Justice Madlanga? Just to repeat what my brother's question was. The brother's question was, when did the unions know for the first time that, now I've forgotten the question, goodness.
There was no money.
There was no
there was no money. Yes.
Yes. Oh, thanks very much, Justice Chike. The unions became aware for the first time when process was to be put in place for National Treasury then to determine the CPI for purposes of determining the increase for 2020-2021. And then that was when now the government for the first time last year said that would like to renegotiate or the revision of clause 3.3. So that was for the first time when the unions became aware. But anyway, we do say that the Minister of Finance intimated already in his budget speech in February that government was going to walk away. So then at that stage, then there was already that intimation. But in March, that's when government clearly said that, yes, we will give you the CPI, but we're not going to pay. So that was for the first time when the union became aware, and that was only last year. And insofar as government becoming aware that it has entered into an invalid agreement, that was when it filed a counter application, which is later than last year when the matter was already litigated before the LAC. So, I think objectively it does tell us exactly what is happening. And government at all material times kept on saying that we are committed to complying with Resolution 1 of 2018, including clause 3.3. So what we can see is happening is that government simply does not have money to pay at this moment, because we know that there are many other problems that have happened. Now, we set out a number of situations which may have come to play of unavailability of money, apart from COVID, of course. I mean, we've set out those factors of corruption and all sorts of things that have taken the money. But we say that that is not a basis for any government in any way in the world to walk away from its obligations, because it sets the wrong precedence to the private sector and to the individual in the street that everybody can walk away the moment they don't have money. The moment they don't have money, can start looking for any excuse and say that agreements are unlawful and so on. So we say that shouldn't be allowed. So those are submissions. Then on the delay, Justice Madlanga, the delay has been raised pointedly by SATU. All I wanted to say so far as the delay is concerned is that we are embracing that argument of delay, and that SATU will deal with it in detail. Then finally, then insofar as the discretion exercised by the LAC is concerned, the LAC simply took into account extraneous factors then to exercise a discretion in favor of the state respondents. And when I say extraneous factors, it has to take into account that there are poor people in need, service delivery, COVID. We say that all those things are irrelevant matters then, I mean, for purposes of holding two parties to an agreement to account. It has nothing to do with that. Governments budget and they plan. So there can't be any issue that because of government's failure to render services, then public servants are no longer entitled to negotiate a living wage. Otherwise, then we are rendering Section 23 of the Constitution superfluous. So we submit that a discretion, of course, falls within the court's powers, but that discretion, and case law is plethora on that, must be exercised judiciously. And in this case, we say that the LAC simply exercised a discretion improperly because it's not one which falls within the judicial exercise of a discretion. And for that, we say that this court should interfere with that discretion that was exercised by the LAC in favor of the state respondents to uphold their counterclaim.
Mr. Mukari, on the question of discretion, where the respondents are saying that they do not have the funds and they are bound by section 7 of the Constitution, and they raise the question of affordability. And if we are with you, you say we must actually uphold what clause 3.3 says that they must pay. Can you do so where we are aware that there's a problem with funding, or should we rather say the parties must go back to negotiate, or what would be the just and equitable remedy under the circumstances?
Yes, actually, so, I mean, Justice Mhlanga, it's a very good question because ordinarily courts do not concern themselves, and I'm talking here in the context of normal contractual disputes. Courts don't necessarily concern themselves with whether the defendant or respondent is going to afford to pay. All what they do then is to hand down an order which must be complied with. So if you have no defense then to the claim, then you must pay. So it's as simple as that. Where and how you're going to get the money is none of the court's business. But in the context of the state, I understand that different considerations may come to play, especially in the situation where we talk of government saying that then it has to then go look for 30.2 or 37.8 billion rands. What we have said as now is that the just and equitable remedy will be for this court to refer the parties back to the bargaining council to go then talk on how then 3.3 can be implemented. So that's then the best we say that will serve a just and equitable remedy. But ordinarily, all what the court will have to do is simply to say that, look, that's your own problem. You must see how to get money. Then we're not going to advise you how to get money, but you have signed an agreement and you have made commitments. Rights and entitlements have accrued to employees, and therefore you must give effect to that. But of course, then we are not really moving for that, as anyhow we're saying that this court can exercise the residual powers to say to the parties, go back to the bargaining council. In any way, that's where the parties were, and the state refused.
This is 5 minutes more from the point my brother Justice Matondo's questions ended, and this is about the most I can allow you, Mr. Mukari.
Indeed, let's end it there, unless if there is a follow-up.
Or was my sister Justice Mhlanga? Did you have a follow-up question? Did you have a follow-up question? I'm very sorry.
I will leave it for later.
No, my sister.
Well, I was just going to say that would be in the event if we find in your favor that clause 3.3 is valid. If we find against you, we don't have to get to the discretion issue. Am I correct?
No, you still have to. No, you still have to do that in the context of 172(1)(b), which will be still. So I'm saying that you can find that it is invalid, but do not set it aside. So that's what I was saying.
My apologies, Justice Mfandla.
As the court pleases.
Very much,
Thank you for the
Mr. Mukari.
indulgence, Justice Madlanga, and you have given me more than enough time.
Thank you, Mr. Mukari. Yes, Mr. Let's see. Mr. Maineche? Where's Mr. Maineche? Mr. Maineche?
Justice Malanga, I just spoke to Mr. Maneche. He says he's
Yes.
been disconnected, but he's trying to connect.
Oh, it's colleagues. Why don't?
Thank you, Justice Madlanga. I'm back.
Oh, thank you, thank you.
Thank you. I'm sorry about that. It looks like there was some domestic mishap.
Yes, I'm just thinking because we take the tea break at 15:15. I'm just worried about the stop start. What about if we take the break now for 15 minutes, which would take us to 11:31. Let's adjourn until 11:31.
As the court pleases.
And you start then.
Thank you, Justice Madlanga.
Court will adjourn until 11:31. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then join with video and sound when the hearing recommences at 11:31. Should you exit, you may use the same link to join the hearing.
I'm shaking my head because I see my maths is wrong there.
They're not appearing.
Is Justice Mhlanhla with us? Thank you. Mr. Manager?
Thank you, Justice Madlanga.
This is proof that you can't trust all lawyers with their maths. I calculated from 11:16 instead of 11:06, the break. Please start, Mr. Manager.
Thank you, Justice Madlanga. We forgive you for that. Like Mr. Mkari, my clients, Satu, Popcrew, and Denosa, became involved in the Labor Appeal Court matter in order to oppose the counter application which was brought to declare the collective agreement invalid. And the answering affidavit for Satu and the other two unions is in volume 12 at page 1198. And the court will see from that answering affidavit and the responses that we received from the government, and I refer to the DPSA and Treasury, that there are really three key issues which arise from the answering affidavit of Satu. The first is whether the LAC misdirected itself in overlooking the delay by government in challenging the validity of the collective agreement. And we shall submit that on binding principle, that counter application was necessary in order to avoid the legal consequences of the conclusion of the collective agreement. The second issue is whether the LAC erred in the finding that the conclusion of the collective agreement by the Minister of Public Service and Administration on behalf of government breached the legality rule and is therefore unconstitutional and invalid. And we shall, in addressing this part of our submission, draw a clear distinction between an issue of validity and the issue of affordability, because those issues are different. And we submit that what the DPSA raises as an issue of validity is in fact an issue of affordability. And we rely on the answering affidavits of the DPSA and Treasury in making the contention that there was substantial compliance with the requirements of Regulation 79. In fact, the compliance gets very close to actual compliance, but I will take the court to the relevant documents which bear our submission out. The third issue is if the collective agreement is invalid, whether the LIC misdirected itself in not granting a just and equitable remedy that involves the enforcement of the collective agreement in any form or manner, including a manner negotiated by the parties in order to implement the agreement. And here, the LAC also misdirected itself in accepting the contentions of government that the unions have already rejected a renegotiation and failed to draw the distinction that the renegotiation which the government previously required was to avoid implementation at all, no increases, even for 0.1% salary increase, no increase. But what the appropriate remedy is that the unions are asking for is a negotiation in order to find a way in which government can implement. Now, those are two different requests, and we submit it was open for the court to exercise the wide discretion under 172 to find in favor of the unions. And then these three issues, we submit respectfully that they engage the jurisdiction of this court. We don't understand National Treasury to be seriously contending that they don't, because it relies extensively on the Constitution itself. But the DPSA makes consistently the argument that the jurisdiction of this court is not engaged. And we submit even that is undermined by the DPSA's own submissions. At the very least, we submit that a finding that the conclusion of the collective agreement breached the legality rule is a finding that the minister acted outside of his powers in concluding the collective agreement, which is then inconsistent with the Constitution. And this court has said many times that such a finding engages the jurisdiction of this court. And it says, and we refer to Affordable Medicines at paragraph 50, but that has been repeated in many other judgments. And in the DPSA's heads of argument at paragraph 83, you'll see that they make the very same argument. They say that the conclusion of the collective agreement breached the principle of legality, is inconsistent with the Constitution and invalid. And they say that is the core issue that this court must decide. Clearly, it's deciding a constitutional issue. And in the course of my address, I will deal with 3 core issues and 2 if I still have time. The first one is the validity of the collective agreement. And in dealing with this, I will have to take some time through the documents. And then secondly, the issue of delay. Thirdly, the issue of remedy. And if there is need, the issue of jurisdiction and interest of justice. I hope that those will be covered in the course of my address in respect of the substantive issues. Now, I start with the question of validity. It is common course that the DPSA's decision on behalf of government to conclude the collective agreement constitutes the exercise of public powers. And the National Treasury in particular has emphasized the reference to AMCU, the decision of this court in AMCU at paragraph 80, that because collective agreements which takes legal effect under section 23 extend to people who are non-parties without their choice, in a sense they are coercive, that therefore that exercise is one of public powers. But besides that, the government says the minister was exercising statutory powers in terms of regulations 78 and 79. So there's can be no issue about exercise of public powers. And we accept that where the government was exercising public powers, the minister was required to comply with statutory limitations. And the next submission we make is on the objective facts which are presented by the Minister of Public Service and Administration, who is the government's agent in concluding the collective agreement. The decision to conclude the collective agreement complied substantially with the statutory limitations in Regulation 78 and 79 of the Public Service Regulations. And we say that the court must determine this issue from the perspective of substance over form. So you're looking at, in substance, what's their compliance, not whether in form can you find a letter with a signature of a minister or ministers of other departments. In summary, and perhaps before I get into the facts, in summary, our submission is that the facts establish the following. First, that the offer of 25 January 2018 that formed the basis of the collective agreement was authorized and mandated by firstly Cabinet, then the Committee of Ministers, and we shall show that the Minister of Finance on behalf of National Treasury in fact made the recommendation which the ministers in the COM accepted to be presented to the unions. And the Minister of DPSA was part of that committee. Secondly, after a Cabinet meeting in April 2018, which said we cannot withdraw the offer that was made in January 2018 because there will be negative perception, there will be criticism about good faith negotiations, and there may be strikes. After that meeting of Cabinet said, according to the Minister of Public Service and Administration, Cabinet said we cannot withdraw this offer. You, the Minister of Public Service and Administration, must engage with National Treasury, the Minister of Finance, to regularize the offer. In other words, Cabinet was cognizant of the fact that they must be compliant with law. Otherwise, regularize the offer would be meaningless. And as you know, we've been deprived of any of those minutes to determine what Cabinet had in mind. But we submit that that can only be what Cabinet was communicating. And on the 2nd of May 2018, the Committee of Ministers met following the Cabinet meeting. And it is at that meeting of the 2nd of May where National Treasury, and this is not just the minister, so there's no breach of Section 216 here. Anyway, it's not breached because the Minister of Finance is the head of Treasury. And in terms of Section 5.2 of the Public Finance Management Act, which gives effect to Section 216 of the Constitution, he makes the policy and other decisions of National Treasury, other than those that he has delegated to others. So, but on the 2nd of May 2018, it was National Treasury that made the recommendation that the offer of the 25th of January 2018 must be made to the unions, coupled with the implementation to be led by the Department of Public Service and Administration to cut costs in order to bring the collective agreement in line with the regulation. And we will show you that first, the DPSA was tasked with taking the lead in introducing the cost-cutting measures in council following the conclusion of the collective agreement. And secondly,
the 10 minutes is up, Mr. Maineche.
Thank you, Justice Madlanga. And the DPSA was required to conduct a proper audit of the public service to identify employees to be invited to take up early retirement or voluntary severance pay.
And can I ask you, while you're busy with that point, can I ask you, is this court not being asked to declare binding a collective agreement, this resolution 1 of 2018, which doesn't comply with peremptory statutory requirements? And Isakawa versus Grade 8 and the SCA not directly against you because I mean, in Sakawa, there was non-compliance with Section 25(3) of the LRA. So if we are we not being asked now by your client and others that we must put place our imprimatur on this collective agreement, which is non-compliant with statutory requirements, which seems to me to be peremptory requirements?
We shall submit, Justice Majid, that first there was compliance. And we say there was substantial compliance, and I'll go to the evidence of the DPSA and Treasury, which bear out that submission. That's the first.
Yes, and that assessment must be made objectively. It doesn't matter whether any one of the ministers or any of the participants thought in their minds that there was compliance or that whatever they did subjectively may constitute compliance. That's something to be determined objectively, is it not so?
Yes, that is correct. And that's why we refer to the objective facts which are put up. So if, and it must also be made in mind, mindful of the purpose of those regulations. So if there is, the test is similar to an assessment where the court is dealing with failure to comply with peremptory legal requirements, whether the purpose is nevertheless achieved and there is sufficient compliance, that will suffice. And
now on the evidence that you've just cited, where the minister said there must be cost cutting and so on, was that not Treasury saying, yes, we can do it on the basis that there must be cost cutting measures implemented elsewhere, and those cost cutting measures on the objective facts were never effected? So it was almost like a conditional okay, and the conditions were never met. Or am I wrong there?
Let me start with the question about conditional okay. Even if it was, let's assume it was a conditional okay from Treasury, that would not be a question of validity of the collective agreement, because what the state needed to do, if that was to be a condition of the collective agreement, was to insist that it will not sign the collective agreement until and unless that condition is incorporated. What government was doing, Justice Majid, was, recall the letter of the 14th of February 2018 by Minister Gigab, where he says you need to, where he was asked to release 15 billion rand to cover the collective agreement that was proposed to be concluded. And he said, I can't release the money. There's no money to release, but you can release money if you implement cost-cutting measures. Now that is the 14th of February. It's followed by a meeting at the bargaining council where the government introduces a an offer which is less than that which was contained in the January 2018 offer. And that was said to have been the second offer that was made of the 25th of January 2018. So in April, when they first meet, Labour rejects the offer less than the January 2018 offer and says they want the January 2018 offer. And then that is followed, and that you will find justices in the DPSA's affidavit in volume 2, page 134, paragraphs 50 to 51. And so when the unions rejected that, then there was a meeting again of the Committee of Ministers on the 19th of April 2018. And you will recall, and that you will find at page 142 of the DPSA's answer in volume 2, in volume 2 at paragraph 64. And there was a presentation by the DPSA minister to that meeting of the Committee of Ministers. And it might be important for the court to have regard to that presentation, because that presentation precedes the meeting of cabinet. And that is in volume 18, and the court will find the presentation at 1780. And the various aspects of that. So first you will see that there is it's noted that after the letter of the Minister of Finance, there was re-engagement between DPSA and the Minister of Finance, and you'll find that at 1782. Then at 1792, you will see in that document that there are options which are considered. You will see these are the options that inform the cabinet's decision later. Option 1 was employer to formally withdraw the offer tabled on 25 January 2018, and thereafter formally table the offer of 4 April in council. You recall the 4 April offer is the one less than the 25th of January offer, which was rejected by the unions. The implications, they say, it will be within budget, and the government will be accused of bad faith negotiations. It will be difficult to manage public perception, and there may be a possibility of labor unrest. And then option 2 is to confirm the employer offer of 25 January with all of that housing allowance and pay progression. Implications, it's outside budget by 30.2 billion rand, and it will remove discussions about bad faith negotiations and public perception, and it will limit the possibility of labor unrest. And then at 1795, you get the cost implications of concluding the collective agreement as per the 25th of January offer. And it's here. So first you will see, justices, that the additional expenditure is spread over the 3 years. You've been given the impression that this illegality concerns only clause 3.3. But if there was illegality, it's of the whole agreement, because the implications are here at 1795 is that the approved budget is 110, what has been called the compensation envelope. And the additional expenditure per year is 6.2 billion, 10.7 billion, 13.2 billion. On this spread, according to this spread, then they should already have been incurrence of the additional expenditure in relation to 3.1 and 3.2. Even if it's at the least at the level of constructing imputing this costs to those financial years. Now, this then goes to cabinet, serves the cabinet, and you will see at what the DPSA tells the court at page 143 at paragraph 66 is that the Committee of Ministers, given this presentation, decided to seek direction from cabinet. And and the cabinet decision followed. And the DPSA tells you what that cabinet decision was at page 144 of volume 2. It's important to have regard to what the minister tells the court at paragraph 67. It says at paragraph 67, page 144, later minutes of the COM dated 2 May 2020 indicate that on 25 April 2018, Cabinet resolved that 1, the Minister for the Public Service and Administration and the Minister of Finance should deliberate on the cost implications of the employer offer tabled on 25 January 2018, and the state was not in a position to withdraw an offer tabled without any coercion, that is the 25th of February. Cabinet therefore instructed the MPSA to regularize the offer and proceed to conclude the agreement with Labour nonetheless. Now, that is the decision of Cabinet. Now, following the decision of Cabinet, COM meets, and it is at that meeting where Treasury makes the presentation.
Mr. Manechi, before you get to the Treasury presentation, you've just referred us to page 144 of volume 2. What does the word regularize mean? What is your submission? With the instruction was that the DPSA regularized the state's offer. Was that to bring it within the ambit of the regulations or the ambit of the amount that had been budgeted for in the compensation envelope?
The ambit of the regulations, because you'll recall that the regulations, if I can just, you were referred to the regulations in the court bundle, but I'll just read you from what it says in regulation 79C. So we accept that it says the Minister of DPSA can conclude collective agreements provided he meets the fiscal requirements of 79C, where there are financial implications, there are clearly financial implications. Then he says under C, the minister may conclude the collective agreement if he or she can cover the costs, 1, from his or her departmental budget. There is no allegation that that could be done. And 2, on the basis of a written commitment from the Treasury to provide additional funds. In other words, what Minister Gigaba was initially requested. Now the LAC said, well, in light of Minister Gigaba's refusal to grant additional funds, there is no other letter in which the Minister of Finance agreed to provide additional funds, therefore the collective agreement is unlawful. But the court was also referred to the Roman 3, which it did not, we submit with respect, consider on the substantive facts. And this is that from the budgets of other departments or agencies with their written agreement and Treasury approval. So, and I'm going to submit that what happened after the what Cabinet wanted to, DPSA to do was to get the agreement of the approval of Treasury, the agreement of other departments to ensure, to see that you can have cost-cutting measures which will release sufficient funds to cover the deficit. And Treasury explains in its answering affidavit before this court that, and I'll come to the reference.
Sorry to interrupt you, Mr. Manechi,
yes,
but the suggestion that there be cost-cutting measures is very different from the requirement in C3 that other departments agree to release some of their budgets.
One has to read that with the explanation by Treasury of what the effect would be of releasing funds from cost-cutting measures. And I'll show justices that in the presentation by the Minister of Finance, by Treasury, departments are identified and what cost-cutting measures could be implemented are identified. But what Treasury explains, if I can just find that reference. Sorry, I just, yes. So it is in the, it will be in the Treasury's answering affidavit in this court. And think my reference should be in volume 20. I seem to have lost my reference to that, but I should get it. So what Treasury, yes, I found the reference, Justices. It's volume 20, page 1935, paragraph 50. This is what it says. There had furthermore been no commitment, written or otherwise, by National Treasury to provide additional funds to bridge the deficit. National Treasury specifically referred in a subsequent letter, that's the letter of Minister Nene, to the fact that the cost implications of the wage agreement amount to 30 billion rand over and above the 2018 MTF baseline compensation budget. The letter further records that this money is not provided for in the current fiscal framework. Accordingly, the shortfall had to be addressed by some 20,000 employees leaving the public service, the letter recorded. It is the money required for this existing through voluntary early retirement, which it was contemplated could be made available through the budget process. But the final amounts to be approved would depend, Minister Nene recorded, entirely on the number of applications for early retirement, the overall fiscal strategy, and obtaining the requisite budgetary approvals. By the date of Minister Nene's letter, thus after the conclusion of the resolution, neither National Treasury nor Parliament approved the 30 billion rand shortfall. So what they're telling you, Justices, is that in terms of the recommendation of Treasury at the COM meeting of the 2nd of May 2018, if the cost-cutting measures were implemented successfully by government, those would free up money in the ordinary budget process and would cover the deficit.
Mr. Manechi,
Now,
can I just...
Yes,
sorry, Mr. Manechi, may I ask, of the three options that Regulation 79 offers for meeting the cost of collective wage agreements, if we go to the second one, on the basis of a written commitment from the Treasury to provide additional funds, however you pitch your argument, whether it's substantial compliance or actual compliance, where in the record will we find the document which you says comes closest to being Treasury's written commitment?
To release funds, additional funds, I can't take a court to such a document. Yes.
Sorry, if we then go to the third one, and this is now the executive authority, I think we are concerned with the Department of Public Service and Administration, or the minister of that department, from the budgets of other departments or agencies with their written agreement and Treasury approval. What is the document in the record that comes closest to being the written agreement of any such other department or agency?
Yes, that is the first, the cabinet decision and the COM meeting where the National Treasury presents the option of cost cutting as recommendations, and that is what is agreed by the ministers in the COM meeting to implement. And recall that the COM is a committee of ministers which is established by section 2, subsection 2, capital A, sub 3 of the Public Service Act. And it comprises of a number of ministers, including the Minister of Public Service and Administration and the Minister of Finance.
So is the cabinet minute, which the respondents have not produced because of executive privilege, do you say that that minute, which we don't have, constitutes the written agreement?
As well as the minute of the COM meeting. Recall that the COM functions as a cabinet committee also. They withhold the minute of that COM meeting.
Can I ask, when one talks about budget and headcounts of 19,000 or 36,000 different numbers feature in different documents, is the budget to pay employees of the state who are obviously work under different departments, are those 19,000 or 36,000 workers whose wages have to be paid and might be saved by cost-cutting measures. Are the budgets to pay them not part of the Department of Public Service and Administration's budget? That's, in other words, the 110 million fiscal envelope is part of the budget of the Department of Public Service and Administration. It's responsible for that payment.
Yes, probably that's right. And so,
so one's not talking, if one's talking about cost cutting by reducing headcounts, one is not talking about getting money from the budgets of other departments. One is talking about saving money in the department's own budget.
That one can look at it that way, Justice Rogers. It would still fall within the Regulation 79, because what was envisaged is that release of funds will then cover the budget for DPSA to cover the shortfall, one. But secondly, if it comes from other departments, it would similarly release funds which would, in the normal budgeting process, be allocated to the DPSA to cover the shortfall.
Assuming that one is talking about cost saving primarily through the Public Service Department reducing its salary cost by reduction of headcount and likewise, then you're under 79C1, that the executive authority can cover the cost from his or her departmental budget. Now, if the departmental budget was 110 billion rand, and a cost-cutting measure, for example, presupposed 19,000 people taking early retirement without pension penalization, that money is not available unless you can find 19,000 people who want to take early retirement. In other words, it's money that might or might not become available depending on what employees do.
Well,
and can a proposal of that kind satisfy 79C1?
Yes, with respect, because it can satisfy C1 or C3, because we're not certain where the salary bill is located for the additional people that will be let off. But the point is that the regulation does not mean that, let's assume that the cost-cutting measures were successfully implemented. And what Treasury explains in its answering affidavit is that the money would then be available through the normal budget process to cover the deficit. Assuming that happened, we submit that we wouldn't be here arguing that the collective agreement is in breach of Regulation 79, because Regulation 79 requires of government in its fiscal decision-making to be assured or to have measures that it will put in place to ensure that what it commits to can be covered. It could not be the case that if the money is not in the budget at present, but can be released through other cost-cutting measures, that is not accounted for under one, because budgets get adjusted during the year. When money becomes available, certain projects are reprioritized and the like. So the point is that at the point at which government is making the proposal to the unions, it's taken upon itself the risk that it shall find the money through cost-cutting measures, and that money will become available through the normal budget process to fund the deficit. And how the government finds money is not a matter for the unions, not a matter for collective bargaining. It is for government exercising its fiscal powers. And that's what is reminding this court repeatedly in its affidavits, in government's affidavits. They make the decision. The decision to lay off employees is government's decision. The decision to cut bonuses, to reduce bonuses, to make the public service more efficient is government's prerogative. It may need to consult unions, but it doesn't need the union's agreement to lay off employees. So government took it upon itself.
Mustn't the union agree with the cost-cutting measures, Mr. Manechi?
Well, that would be best practice, but it doesn't have to by law, because when you offer voluntary severance packages and people don't accept them, and you decide to retrench, all that you're required to do is to consult the unions. You don't need agreement of the unions. In fact, the reason the unions refused to incorporate layoffs in the collective agreement is made clear in the answering affidavit of SATU, and the court will find that if I can just find my reference again, yes, that we'll find that at page 1228 of volume 12. And the minutes which SATU has attached to the answering affidavit, which are additional minutes of the negotiations in volume 13, will show that what government told the unions is that it will shortly be introducing cost-cutting measures. And it had to say that because it has to conduct the necessary assessments to see where it can cut. And that was DPSA's job in terms of that presentation of COM. And I just want to first refer you to what the union said, what SATU says at page 1228, paragraph 95. It says, the gist of the trade union opposition was that the employer needed to first develop a comprehensive human resources plan that would detail, amongst others, an appropriate skills audit to avoid the public service losing skilled personnel that is required. Further, that the cost-cutting measure of reducing headcount by 30,000 employees contradicted research by National Treasury that the South African public service employed less skilled public servants, which contributes to poor service delivery. Reducing headcount drastically could have adverse effects on service delivery as the remaining public servants would be overworked. That is to say, government, go do your work. When you come and present cost-cutting headcount, you must have done this human resource proper planning, and that's DPSA's function. And,
Mr. Manechi?
Yes.
Sorry to interrupt you. On the factual exposition that you have set out before us, the compliance with Regulation 79, C, either 1 or 3, wasn't that conditional? Was conditional upon the cost-cutting measures being able to be implemented.
So if that's the case, Justice Teron, will the court be saying the government conditionally breached legality? Because if it had succeeded, then it would not have been in breach of legality. That's why we submit that that issue is an issue of affordability. It's not an issue of validity. And they're conflating the two issues. And the reason we say this also is, I know that parties are not bound by what they say in affidavits, but the DPSA itself said in its replying affidavit, recall in the SATU affidavits, SATU goes to great lengths to say, what you're asking the court to believe is staggering, that cabinet said and decided to breach the law. They say, no, cabinet did not breach the law. The offer was lawful because the cost were to be covered from the cost-cutting measures. And that's what they say there in the replying affidavit is consistent with what counsel for the DPSA submitted to the LAC. He submitted to the LAC that there was compliance with Regulation 79 where the collective agreement was concluded. What rendered it non-compliant and invalid was the fact that it became unaffordable because the cost-cutting measures could... Yes, and I wanted... Yes, Justice Madondo?
I'm sorry to interrupt you before you go further and further. May I understand your argument? Because your argument is that the money was somehow available, but on the other hand, you say the minister indicated that there was no additional money to be paid in, and the money can only be covered from cost-cutting measures. Does that not clearly indicate that there was no money at the stage?
What we are submitting, Justice Madondo, is that the question whether government complied at the time of the conclusion of the collective agreement cannot be answered by whether there was money in the bank or not, or in the budget. Because government at that point decided that it was going to cover the shortfall through cost-cutting measures which would be implemented once the collective agreement is concluded. So the only time when you will be looking at whether there is indeed money is after they've implemented the cost-cutting measures. But when you look and find that there is still a shortfall, what you're asking yourself is not a legality question, it's an affordability question. And that's what...
At that point, the 40 minutes is up, Mr. Moinetti.
Is it up? All right. I just want to give...
Langa, if I could just conclude with one question.
Let's first see if Justice Madondo is done. Justice Madondo?
Yes, please. Maybe let me allow Justice Turan to go ahead. I'll come after her.
Thank you, Justice Madondo. I'd just like to conclude with one question on our earlier discussion, Mr. Monetti. So the committee of members said to DPSA that it had to cut costs. The mandate given by Cabinet was subject to cost-cutting measures. So when DPSA didn't introduce the cost-cutting measures, it had in fact breached the mandate it had received.
Well, but you can't test that on the date of conclusion of the collective agreement, because the only breach, you recall that they have provided you with evidence of circulars that they sent out to try to implement the cost-cutting measures. That is in 2019. And if I can give you those circulars, the references to those circulars, and those circulars also underlie an important point, which is that the implementation of the cost-cutting measures was not dependent on the agreement with the union, because that is implemented. Even Minister Nene's letter of June 2018 is calling upon DPSA to implement the cost-cutting measures. He's not saying this collective agreement is invalid. And the cost-cutting measures you will find in volume 4, firstly, at page 377, that is on performance bonuses. And you'll find a second one at volume 5 at page 380 on early retirement. What is spectacularly evident that DPSA just failed its job is that when it asks for early retirement in volume 5 at page 380, it is responding to requests by employees wanting early retirement. It is not taking the proactive step of assessing the public service and identifying areas where cost-cutting measures may be implemented. And I was going to refer the court to the replying affidavit of DPSA where it said it complied with the agreement. That's in volume 14 at page 1379 and its paragraphs 29 and 30. And its complaint is that the unions frustrated the implementation of cost-cutting measures. But Mr. O will come back later after me. He'll say his members, unions members applied and some were refused early retirement. So with great respect, it is the DPSA, it is government that is asking the court to release it from a collective agreement properly concluded on the basis that it has failed to comply with the mandate it was given by Cabinet and by the Committee of Ministers. And I mustn't forget to give you the reference to the Committee of Ministers meeting of 2 May 2018. It is in volume 4 at page 315. And when you look at that, you will see that that minute is very useful. It recounts the wage offer scenarios and the meetings that took place at page 334 to 336. It then deals with exit strategies, looking at various departments at 342 to 344. And then the National Treasury, represented by the minister, makes the recommendations, which is then approved by the committee of ministers, and it is that recommendation which is then forms the basis of the offer to the unions. And you'll find that at page 350 of that volume. And can I just give you as another reference, in volume 13, annexes to SATU's answering affidavit, and there you will find the minutes of the 2 May until the 21st of May. And you will see at page 1312 that all government said was that it intended to introduce in council cost-cutting measures shortly. And then you will see that before the agreement was signed, the parties took a break to go and take fresh mandates. And you will see that at 1313. So that is on compliance, and I'll deal with other matters if they arise, when they arise in reply. But in summary, what we're saying is what I submitted, this substantive compliance.
Just a minute, Mr. Manager. Justice Throne.
I am. Thank you, Justice Matanga.
Thank you. Yes. Thank you. Let us manage time, Mr. Manager. How much?
Yes. If I get only 5 minutes, I shall conclude.
Thank you very much.
Yes. On the delay point, you will recall that the DPSA says we did not raise a collateral challenge under PAJA. Of course we don't, because there's not PAJA here. But what we did raise is at page 1213 of volume 12. And it was this, that the counter application is intended to avoid the legal consequences of the collective agreement that the government has implemented for 2 years. It has complied with clauses 3.1 and 3.2 of the collective agreement over that period without demur. Its challenge to the enforceability of the clause 3.3 has been brought after a significant lapse of time. The DPSA and Treasury offer no explanation whatsoever, let alone a reasonable one, for this delay. It will be submitted at the hearing of the application that the counter application is of the kind that requires government, represented by the DPSA and Treasury, to explain the delay and ask the court to condone, meaning to overlook it. Failing this, the counter application should be dismissed. And we have referred the court to the Kijima judgment, Kumalo and Merafong and Keland, and all of which, following EFF also, are to the effect that an exercise in a decision made under statute involving the exercise of public power has legal consequences and cannot be ignored until it's set aside. That's the collective agreement in terms of AMCU. And that if you want to have it set aside and you have delayed, you must offer an explanation. If you don't, the delay is unreasonable. The court may refuse to enter the debate unless the illegality is so clear and not disputed. And we have referred to the relevant cases. We referred to the judgment of Justice Rogers in Central Energy Fund in the Western Cape, not because it binds this court, but because Justice Rogers summarizes all of this case law at paragraph 289, I believe it was, of the judgment, 296 rather. Sorry, I think it's 289. I was right the first time. So, and in the affidavits in the LAC, no explanation is provided by the ministers. What they say is that their challenge is not late because they tried to negotiate in March 2020 to avoid implementing, and therefore that's good enough. But Tasima, Justice Madlanga, and I can't recall now the other justice that wrote the judgment with Justice Madlanga, made short thrift of that kind of argument that one.
I will not own Tasima.
Yes, that made short thrift of the argument that the delay starts running when we got advice that it was unlawful. No, it runs from the date of the illegality, the date of the conclusion. And we've showed, the documents show that the illegality was appreciated even before, if there was an illegality, even before the conclusion of the agreement. So we submit that this is a case in which, absent an explanation, the court misdirected itself in exercising a discretion to overlook the delay. And then the question of remedy, we submit that for a number of
Before you get to remedy, Justice Madlanga, I know that time is against us. Can I just have an opportunity, short legal question? Mr. Maineje, Nehao showed us where they say they relied on Section 23 of the LRA. Was
Yes.
there any reliance by your client on Section 23 of the LRA? Can you just give me the reference there?
Yes, Justice Chitri, I had forgotten to do that. If the court looks at volume 12 from page 1205, you will find a complaint by SATU about government's lack of good faith. In there, we cite the LRA paragraph 23, we cite section 1C of the Constitution and 2 of the Constitution, we cite section 23 of the Constitution, we cite section 23 and 32 of the LRA, we cite 85 of the Constitution, we cite 91, all the sections dealing with executive power, and we conclude by saying if you allow government to walk away, you undermine collective bargaining, because part of the sanctity of collective bargaining is that collective agreements lawfully concluded should be enforced. And we've quoted KUSA, and we say all of those, we relied squarely on the Constitution and the LRA, because they also say that subsidiarity precludes us. We relied on both the Constitution and the LRA.
Now, what is the import then of Section 210 of the Labor Relations Act on the argument about invalidity of the regulations?
Yes.
You will recall that Section 10 says that if any conflict relating to the matters dealt with in this act arises between this act and the provisions of any other law, save the Constitution, or an act expressly amending this act, the provisions of this act will prevail.
Yes, our learned friends for PSA deal with that extensively, but even the PSA itself starts off at section 2, capital A, that whatever powers it provides are subject to the Labor Relations Act and any collective agreement. So we would submit that to the extent that the Labor Relations Act says collective agreements concluded in council are binding and have legal effect, and that conflicts with Regulation 79, the LRA would prevail.
Thanks, Justice Madlanga.
Yes, and if I can just, thank you, Justice. If I can go to remedy then, what we say is that the court has wide discretion, and the discretion here should be exercised. The discretion arises in two forms. The first is the National Treasury says, even if the collective agreement was valid, you must not enforce because there are far-reaching implications fiscally. And then secondly, we say, even if it's invalid, you must enforce it. To both of those, first to the argument of even if it's valid. This court has said in KwaZulu-Natal versus KwaZulu-Natal Joint Liaison Committee versus MEC for KwaZulu-Natal, that where government has made an undertaking, a promise lawfully within its statutory powers, it must honor that undertaking. And if the collective agreement is valid, it must be honored in light with that provision. And in fact, Treasury says, if it is forced to comply, it will have to do one of many things. One is it will have to redirect funds away from dealing with other competing constitutional duties. But we say, secondly, it can also comply by doing what it agreed to do at the COM meeting of the 2 May 2018, which is to implement cost-cutting measures. It has, in the implementation of those cost-cutting measures that it complains about, it released 3 billion rand. And it also says from the 30.2 billion rand, currently the cost, the National Treasury says the cost of implementing is about 29 billion rand. So there's some money somewhere, or some money unaccounted for, but they don't even want a 0.1% salary increase. So we submit that one can't let government walk away. It has implemented cost cutting, released some money. It has saved on negative public perception and industrial relations and the likes. It must be compelled, at the very least, either to comply or to go back to the negotiating table for purposes of implementation, as we've asked for as SATU. And we submit that
the principle emerging from joint liaison is subject to a rider.
Yes.
that the state must pay if there's an overriding public interest for doing so. In this case, the ministers have put up evidence suggesting that it is in the public interest to refuse enforcement of clause 3.3. What do you say to that?
No, we say that that can't be right. First, it's legend in the case of this court, government must lead by example. But secondly, the prejudice goes to the heart of collective bargaining. And collective bargaining is at the heart of the LRA to manage industrial relations and to improve the conditions of workers in the public sector and in the private sector. But if an employer can say, I don't have money anymore, I failed to budget properly, I've mismanaged public funds, there is corruption, and I failed to implement cost-cutting measures which I promised to implement, and the highest court in the land must let me walk free. We submit that that cannot be in the public interest, because the implications for workers generally are far-reaching. They say we are arguing a sloping scale or kind of argument, but that is true. That is where we come from. That's why we have Section 23(5) and we have the LRA. Workers cannot collectively bargain individually for better improvements of their living conditions. So we submit that that plea about budgets, which this court has had many times from government, is not fair, is not a valid basis when countenanced against the implications for collective bargaining under the Constitution. So we submit that the remedy we propose is just an equitable one.
Mr. Manager, if we are against you, we overlook the delay, we find that the resolution 1 is invalid. I know that you refer me to section 172 and also the substantial compliance argument. Why should we allow you to and grant you the relief under clause 3.3 when we know that government should not have paid even in respect of 3.1 and 3.2?
Well, if you reach that conclusion that they shouldn't even have paid under 3.1 and 3.2, in terms of Bengwenyama and the cases of this court, you first have to consider what impact that has on the parties affected. So clearly, public servants here have fashioned their lives on the basis that the collective agreement was valid, because that's what government presented to them. And that is an interest to be considered. And then also the public interest. And I've submitted the public interest in relation to the collective bargaining. Now, the issue about the impact of COVID is not limited to employees other than public servants. It's also impacts upon public servants in that they were promised salary increases, which are now zero for the past year. And they too have adapted their lives accordingly. And government can't be allowed to walk away. But what government can be allowed to do is to look at ways in which this can be implemented by negotiation in a way that affords it room. We accept that they say even that is not possible. But government can't keep saying everything is impossible. And we submit that that would be a proper remedy. And it's not moot to do that because it's akin to a salary claim. You can't say, well, your salary claim has been lost because you're no longer an employee. In any event, the terms of and conditions of employment here, we say, have become, the collective agreement has become part of the terms and conditions of employment. So they're claiming for unpaid increases. And that can never be moot.
So the negotiation would be based on the very same clause that is supposed to be invalid? Or are you talking about fresh negotiations altogether?
No, it's the same clause. So we're asking the court to suspend the declaration of invalidity and allow for them to negotiate. And that's in the discretion of the court, of course, to fashion such a remedy if the court is convinced that it can and should on the facts of this case.
We can't, is it open to us to say any negotiation relating to that year that is now gone and past because we are no longer talking about 2020 and 2021? Is that something that one can argue about?
That they must reopen the negotiations of that year?
No, I'm saying we know that the negotiations related to 2020 until March 2021. Can one then go back and renegotiate in respect of the increases for the past year, financial year?
Yes, so what we are saying is that the negotiations were for the 3 years, as the court is putting to me, and the agreement was concluded and terms and conditions were changed. But the government reneged on part of that agreement. And the question is, if it says it can't afford to pay those salary increases, and that's the issue the court is grappling with, we submit that a just and equitable remedy is for government not to renegotiate the actual salary increase for that year, but to renegotiate how it implements 3.3 in whatever form that would be possible for the government. That's important also for accountability, because when those negotiations take place in the council, the government would have to bear it all about the state of play at that point in the finances of government on what is or is not possible. And if there is no agreement, there is no agreement. But the remedy we seek is not to reopen the negotiations for the entire 3 years, but only to negotiate about how to implement 3.3. Those are our submissions.
Thank you very much, Mr. Maineche.
Just Madanga said, thank you. Thank you for that indulgence. As the court pleases. We ask for the prayers in the notice of motion, obviously. Thank you.
Thank you. Mr. Orr.
Thank you, Justice Madlanga and members of the court. I'd like to refer the court to our practice note and the flow chart that is attached to our practice note, because that is going to be the structure of the presentations that I will make to the court today. And really what the flow chart sets out is the various questions or issues that the court has to deal with and the consequences of a finding in respect of each of those issues. And we also make the point that at each stage, when you address yourselves to those decisions and those issues, you have to bear in mind that one is dealing with a collective agreement, that one is dealing with the right to collectively bargain, and that if collective agreements are not upheld where they can be, the right to collective bargaining becomes entirely empty and meaningless. So if as I say, the first question then, as set out in the flow chart, is, has there been compliance with Regulation 79? And that's a question of, has there been actual compliance or has there been substantial compliance? My learned friend, Mr. Maineche, has done a sterling job on dealing with the question of compliance. And I'm not going to waste the court's time on that much more. I don't think I can do as good a job as he has already done. We just make one additional point in relation to complete compliance, which is that the regulations themselves provide that the Minister of the DPSA can authorize a deviation from any of the regulations. And that authorization does not need to be in writing. It is simply an authorization by conduct, by whatever means, by the Minister of the DPSA. He can say, well, all of these regulations are not applicable in these circumstances. And we make the point that his conduct in ultimately concluding the collective agreement should be viewed as a deviation in terms of Regulation 4. So we just add that to the pot of what was argued by Mr. Maineche on complete compliance. When we move to substantial compliance, we would urge the court to have not only to the regulations themselves, but also the general contextual purpose of the regulations as read with the various provisions of the Public Service Act. And we've set those out in the heads. Because when one is dealing with a question of substantial compliance, the question one is really asking is, was the purpose of the regulations served? And that question cannot be considered in isolation by just looking at the regulation concern, but needs to be looked at in the broader conspectus of the Act and the other regulations. Obviously, if the court is of the view that there has been either complete compliance or substantial compliance, then the agreement is valid and enforceable. If the court is of the view that there has not been compliance or has not been substantial compliance, we then move on to the point that we have made, which is, does the doctrine of ostensible authority or estoppel apply in this particular matter? And Justice Turon raised that question with my learned friend, Mr. Macquarie. And I want to just make it very clear right at the outset that we accept that either ostensible authority or estoppel can only apply if the court is persuaded that Regulation 79 is an internal regulatory mechanism rather than a power conferring something that confers actual powers. And that question again can only be properly interrogated and properly dealt with when one looks at the regulations and the PSA, the sections of the PSA dealing with collective agreements in their totality, because it's in that contextual sort of environment that the court can properly apply its mind to the question of, does Section 79 confer a power or is it an internal regulatory mechanism? And we would obviously urge the court to come to the latter conclusion. And I want to spend a bit of time on this issue because it's not really an issue that's been covered in any detail by either of my previous learned friends. The first regulation that needs to be considered is the one we have referred to, is Regulation 4. If it is so that the Minister of the DPSA can make a decision to authorize a deviation from any regulation, including Regulation 78 and 79, we would suggest that that's a very strong indication that Regulations 78 and 79 are internal regulatory mechanisms and not power conferring regulations. It would seem to us to be profoundly anomalous if the minister can decide whether Regulation 78 and 79 applies, but it must still be found that this is not an internal regulatory mechanism, but something that confers power on the minister in specific circumstances. So in other words, if it's a power conferring mechanism, he may not act until that power is conferred on him. However, he may act by authorizing a deviation from that power conferring mechanism and then act completely contrary to the regulation in the first place. So the submission is that that is a very strong indication that these regulations are internal regulatory mechanisms and not power conferring mechanisms. In our heads at paragraph 81, we detail various other provisions of both the Act, being the Public Service Act, and the regulations, which reinforce our argument that a proper understanding, once those two regulations, 78 and 79, are placed in their proper context, that they are internal regulatory mechanisms rather than power conferring mechanisms. We start at paragraph 81.1 of our heads with section 3 of the Public Service Act. Section 3 of the Public Service Act gives the minister of the DPSA minister the power to make wage determinations, and he may do so, or she may do so, only in consultation with the Minister of Finance. In other words, a minister can make a wage determination without any authorization from the Minister of Finance, provided there has been consultation with the Minister of Finance. Now, obviously, this is not a wage determination that we are dealing with in this particular matter. We're dealing with a collective agreement. However, Section 6A of the Public Service Act provides that any provision of a collective agreement contemplated in subsection 4, concluded on or after the commencement of the Public Service Amendment Act, shall, in respect of conditions or services of employees appointed in terms of this Act, be deemed to be a determination made by the Minister in terms of Section 3.5. So a collective agreement becomes a determination in terms of the Act. In terms of the Act, a Minister can make a determination with no more than consultation with the Minister of Finance. But the state would have the court accept that the regulations of 78 and 79, which set out the various specific requirements, must be complied with for a collective agreement to come into play in the first place, notwithstanding that collective agreement then becomes a wage determination, which did not require anything more than consultation with the Minister of Finance in the first place. So again, we would submit a very strong indication that what we are dealing with in regulations 78 and 79 are internal regulatory mechanisms rather than power conferring mechanisms. Paragraph 81.3 of the heads deals with Section 2A, which sets out the powers of the Committee of Ministers. And it sets out that the Committee of Ministers, when determining conditions of service, must do so subject to any collective agreement. So the Committee of Ministers may not depart from the provisions of any existing collective agreement. Again, we make the point that this is again an indication of how the Act itself stresses the primacy of collective agreements over both the regulations.
Mr. Orr, the 10 minutes is up.
Thank you.
You may continue.
Thank you. The Act stresses that collective.
Sorry, Mr. Orr. Just on deviation, Mr. Brainders makes the point that there has to be a factual substratum which relates to justifiability. What do you say on that? Which, as I understand the argument, has not been addressed for you to be able to raise
Justice Madlanga, as I understand, I accept the point that the court must find on the facts before them that there has been a deviation. We would submit that the facts do support a finding of that. When the Minister of the DPSA decides, and that's obviously only if there's a finding that there's been a departure from Regulation 78 and 79 in the first place. The Minister, assuming there has been a departure, and we don't, and I'm not going to revisit the issue, but assuming there has been a departure, then the Minister, in the face of that departure, concludes the collective agreement with the union. Now, we say on those facts, you must either find there has been a deviation, or you must find that the state has decided to act unlawfully in order to deprive the unions of their right to strike, because that is why they say we must conclude this agreement. They say, listen, we have to conclude this agreement because otherwise we're going to be accused of bad faith and we're going to face a strike. So we must conclude an agreement. So either the court must find on those facts that the state has chosen to act unlawfully, in full knowledge that it is acting unlawfully, or the court must find that in fact what happened is that the minister authorized a deviation from the regulations. The other point made by Mr. Brainders is that we didn't plead that in our founding affidavit. And there's a very simple answer to that, Justice Madlanga. The first time non-compliance with the regulations is ever raised with any of the unions is in the answering affidavits from the state. It is not as if when the negotiations, when in February and March, the state sits down with the unions and says, look, we'd like to renegotiate. The state says to the unions, you know what, these agreements are actually unlawful. We didn't actually have to comply with these agreements. We chose to. They're unlawful, and we're not going to comply with them going forward. If that had been said, yes, then Mr. Brainders would have had trenchant criticism to say we should have dealt with the question of a deviation in our founding affidavit. In fact, the DPSA should have dealt with the question of a deviation in their answering affidavit, because they were the ones setting up the illegality, non-compliance with regulation defense. They should have said there wasn't compliance with the regulations, and notwithstanding the fact that the minister actually entered into the agreement, this does not amount to a deviation in terms of regulation 4.
Mr. Orr, the deviation point is being raised for the first time in this court, is it not?
That is correct.
Is it proper to do so and for this court to consider it at this stage as a court of first and last instance on that aspect?
We would say it is properly raised. It is a legal point. We are not raising any new facts to support the argument. We are simply saying that I've already indicated the dichotomous choice there really is on this. Either the minister in entering into the agreement authorized a deviation, or if the court feels that there's insufficient facts on which to come to that conclusion, then the conclusion is that the minister and the state deliberately acted unlawfully in order to deprive the unions of their right to strike on the wage dispute.
Yes, in Tiki Dry, this court set out certain circumstances where a point could be raised, possibly be raised for the first time in this court. Does your client pass that test in this matter?
My lady, we would submit we do.
Is there a reason why this point was not raised earlier?
My lady, it was not raised earlier because, as I've indicated, the unions were not aware of non-compliance with the regulations until this was raised in the answering affidavits of the state. It's the state's case that there is non-compliance with the regulations. The state then needs to satisfy the court that non-compliance includes compliance, as it were, with regulation 4. In other words, that there has not, that these facts do not support a deviation authorized by the minister.
Are you saying the state respondents? Please go ahead, Justice Madlanga.
No, I wanted to say that would be a very unusual way of pleading, Mr. O. It's very much like saying a defendant or a respondent would even have so far as to say, and I'm not stopped, instead of waiting for the other side to say, and you are stopped. It sounds very odd to my ear.
Well, Justice, I can take it no further than the point I've made, which is that the non-compliance is raised for the first time. It is never raised in negotiations with the unions. It's never raised it is raised for the first time in the answering affidavit. It's not even raised in the correspondence. But I cannot take this issue any further.
Yeah, just on that, Mr. O, and it just seems to me that the facts also don't support the argument that you're making. It seems to me that the facts demonstrate that the minister of the DPSA was under the impression he was mandated to conclude the collective agreement, not that he was authorized to deviate from the regulations.
Well, my lady, then, Justice Ron, if he was mandated, then the agreement must have been lawful.
Well, mandated subject to the conditions that Cabinet gave him.
I mean, on that, I can only echo my learned friend, Mr. Maineche. I don't understand how an agreement can be conditionally lawful or conditionally unlawful. It is either if the compliance with Regulation 79 is a sine qua non of legality, then the agreement is either lawful or not lawful. It can't be conditionally lawful.
Do your clients say that National Treasury approved the conclusion of the collective agreement?
We say there's been substantial compliance with the regulations, Justice Trump.
And what do you rely on for substantial compliance?
Well, we rely on the fact, the presentations made at the various Committee of Ministers meetings, the presentations of April, where the Minister of Finance is present, The fact that the agreement is going to exceed 30 billion is a fact that is accepted by everybody. But notwithstanding that acceptance by everybody, the Committee of Ministers, including the Minister of Finance, says we must present these three options to Cabinet, only one of which complies with the regulations. Signing the agreement.
Yes, the presentations that you refer to, Mr. Orr, are these the presentations that appear in volume 18? And in particular, page 1792 and 1793.
That is correct. That is the first committee of Ministers meeting, the one just before the Cabinet meeting.
Yes, and these were proposals, and one would see at 1797 that they subject or that the intention of the measures is to ensure that there is limited impact on the budget.
Yes, that is correct.
Is that condition? Would that be conditional?
Well, it's not conditional per se, Justice Turon. I think what they're saying is, look, we are in a grim position here. We've got three options. The one is we sign the agreement and then we're outside the compensation envelope.
Yes, and then they say there should be limited impact. Do you say a budget that's exceeded by 30% would not be a limited impact?
Sorry, I don't follow the 30%.
Well, the 110 billion was exceeded by 30 billion.
Yes.
Is that a limited impact?
It is not a limited impact.
And that would be contrary to what the presentation was, or what is stated in the presentation?
That's where we depart from each other, Justice Turon. The three options that are presented to Cabinet are firstly to sign the agreement as it is, which involves going beyond the compensation envelope. The second is to withdraw and insist on the signing of an agreement that is within the compensation envelope. That option is within the compensation envelope. The third option is to sign the agreement, but try and bring the level by which it impacts in excess of the compensation envelope below 30 billion. There's no suggestion that the cost-cutting measures will achieve savings of 30 billion. The option 3 is to bring it down below the 30 billion possible. If I can just refer the court to, that's at page 1793. (1793) sets out option 3. Confirm the employer offer of 25 January with respect to cost of living allowance, housing allowance, and pay progression. Commence negotiations with a view to finding a settlement within plus or minus 30.2 billion over the MTF. So the cost savings are not and never were envisaged to bring the cost of the agreement within the compensation envelope. The cost saving measures were to try and reduce the amount by which the compensation envelope would be exceeded.
So if I understand your argument then, which you've just advanced, on that argument, there would not have been compliance with Regulation 79.
We say there's substantial compliance because the Minister of Finance says, yes, place these three options before Cabinet. The Minister of Finance says 2 of the options which are in excess of the envelope should go before Cabinet and Cabinet should make the decision. Cabinet then makes the decision. Cabinet says, we're going to sign the agreement. And why are we going to sign the agreement? Because we don't want to strike. Then there's a further meeting of the Committee of Ministers. And their presentation is made by the Minister of Finance. And the Minister of Finance starts presenting short, medium, and long-term options to try and limit the amount by which the agreement exceeds the compensation envelope. When the court has a look at that presentation in detail, and I don't have the time to take the court through the presentation in detail, you will see it is not a question of bringing it within the envelope. It's trying to limit the damage beyond, trying to limit the damage beyond the envelope. And that is the Minister of Finance making that presentation. And that presentation is made prior to the signing of the agreement. So we say on those facts, where the Minister of Finance is effectively saying, we must accept that the compensation envelope is going to be exceeded. We must try and limit by how much it is going to be exceeded. We say that amounts to substantial compliance with the regulations.
My last question on this aspect, Mr. Orr. The presentation by National Treasury, which we find at page 349 of the record, volume 4. And National Treasury records that the increases in salary must be broadly in line with CPI inflation, are both reasonable and fair, and that the fiscal framework approved for the 2018 financial period to be upheld through implementing cost-saving measures. Was the National Treasury saying that it must be within that budget of 110 billion with cost-saving measures?
My lady, again, I mean, Justice Geron, we depart from each other here. I think if the presentation is looked at it in its entirety, there is an acceptance by Treasury that the compensation envelope is going to be exceeded. Again, this is not a matter I can take any further. It's a question of how one interprets the presentation in its totality. Our submission is, if you look at the totality of the presentation by National Treasury, there's an acceptance on Treasury's part that the compensation envelope is going to be exceeded.
But the final bullet point on page 349 says the fiscal framework approved is to be upheld. And how it's to be upheld through the cost-saving initiatives.
I accept that is what the final bullet point on page 349 says.
Thank you, Mr. Orr.
I wonder if I can just follow on, Mr. Orr, from what my colleague has just been asking you about. You would accept that it's not substantial compliance with Regulation 79 for an executive authority to say, I can cover some, but not all of the cost of this deal through cost cutting. The cost is either covered or it is not. I'm not talking about money that's de minimis, but the requirement is that the whole cost must be covered from one of the three sources.
Indeed.
So is your argument in your answers to the questions you've just given to the effect that the cost-cutting measures were never going to completely eliminate the 30.2 billion excess, that National Treasury through the Minister of Finance must be taken to have agreed to make good any shortfall?
That is precisely our argument, Justice.
So that although one doesn't have the written commitment contemplated in Regulation 79 substantially, that is what happened.
That is precisely our argument, Justice Rogers, yes.
Now, what does one then make of the mandate that I understand was given? If you look at volume 19, starting at page 1905, this is a document in similar form to Resolution 1 as adopted, and in its salary component seems to be identical. There's some differences later on, but it starts at 1905. This, as I understand, is what was mandated. And if one goes to 1910 at the end, in bold print, the total cost implication is noted in point 1. Point 2, the employer is going to try and get away with a bit less. And then 3, this offer will be tabled together with a presentation on constrained financial environment, and that this offer does not inject any new funds into the current personnel expenditure ceiling of 110 billion. And then for council records, the employer will identify areas that will be explored to ensure that the personnel expenditure ceiling is maintained. And that is then, at least it's not signed in the version we have, but that appears to be by the two ministers. So it seems to me point 3, the mandate explicitly was no new funds will be injected. So, and as I read point 3, it seems to be some hope that maybe they will be able to do it through cost cutting.
That does seem to be the reading, Justice Rogers.
Now, can it be compliance with the rule of law in the face of these regulations that one commits 30 billion rand of public money on a whim and a wing and a prayer, if I can put it that way? No concrete computation of how you're going to make up the money, no certainty that it's going to eventuate, not even raising it with the unions. I appreciate the unions may say, what are we to know about all of this? How are we to control that process? But looking at it from the point of view of the broader public interest and the principle of legality, how can that be tolerated?
Well, Justice Rogers, I would submit it can be tolerated because that was the view of government. The view of government was that they would be able to reduce the amount by which the agreement exceeded the compensation envelope. Whether that's prudent is another debate entirely. But whether that, our point is that there is the substantial compliance point, which is that there has been, on these facts, substantial compliance with the regulations. In other words, that the minister is involved and has given his approval to a process where a collective agreement is going to be signed, which is going to exceed the compensation envelope.
I presume you would accept that subject to a lawful deviation under Regulation 4, even if the whole cabinet says we resolve to disregard regulations 78 and 79, that wouldn't pass legality muster.
Yes, we do accept that.
And Regulation 4 deviation, there would have to be justifiable circumstances.
Indeed.
And it seems to me everything we've read in these papers suggests that the financial circumstances as they stood in May 2018 made these increases, at least on what was in the state coffers at that time, unjustifiable.
Well, justifiable doesn't necessarily only have to relate to finances. The argument could be we are justified in avoiding a strike. And those are the justifiable circumstances which warrant a deviation from the regulations.
But either way, there would need to be an application of the mind to and balancing of the justifiable circumstances.
There would indeed.
Thank you.
Mr. Orr, isn't this the way bargaining in the public sector works? That ultimately you need the signature of Treasury to sign off on a deal. That's what the PFMA requires. You can't go, as my colleague puts it, on a whim and a fancy that there's substantial agreement. But is it not also, as you point out, that this was, I wouldn't say a trick, but a tactic to subvert a strike? So until you've got a written agreement from Treasury, you've got no agreement.
Well, the written agreement from Treasury is only a requirement if you're going to exceed the budget, which we accept is what was going to happen in this case. But it's the only conclusion that can be drawn here in relation to the state's conduct is if their conduct was indeed unlawful, it was purely done to avoid a strike. There was no other reason, but because, obviously the effect, as all the justices will know, the effect of the conclusion of a collective agreement is it deprives employees the right to strike. And in the case, for example, of my clients, they did not even agree with the collective agreement, but they were bound by it, and they were unable to strike about their terms and conditions because a collective agreement was concluded. So what one has, and this is something that obviously has probably more significant bearing further down our flow chart, which is if the court is of the view that there was non-compliance with the regulations, what do they do with it? The state, the only cogent sort of interpretation that can be put on the state's conduct is that they decided they did not want to strike, and if need be, they were going to tweak or bend the regulations. If there are no more questions at this stage, perhaps, thank you, Justice Malanga.
Sorry, Mr. O.
Certainly, Justice Madonda.
Yes. If I understand your argument quite correctly, the unions knew by then that the money or the amount was not sufficient to cover the cost of the implementation of this agreement.
Justice, when you say they knew by then, do you mean when the agreement was concluded?
Yes.
Justice, they did not know by then that there was insufficient money. They didn't have insight into the budget in the same fashion as the state did. And you know, let's be frank, when one's dealing with a collective bargaining process, employers are always going to plead poverty. It's not as if an employer is going to come to the collective bargaining table and say, you know what, this year we actually are doing exceptionally well and our proposal is 4% wage increase. Yes, certainly in the negotiation process, the state said we have financial constraints, we have difficulties, etc., etc. But that does not amount to the unions having detailed knowledge of the amount by which the agreement exceeded the compensation envelope.
So if that was the case, there would be no need for a talk of getting another man who is going to limit the amount by which the amount which exceeded the compensation envelope.
Well, not from the union perspective, no, Justice Masonda. The union.
I know from the government perspective, because the minister indicated that there should be some cost-cutting measures put in place so to be able to bring this approved compensation envelope.
Well, there are 2 points really to make there, Justice Masonda. Yes, there was some discussion of cost-cutting measures, but those were cost-cutting measures which, again, your line of questioning, Justice Masonda, started with this point about the union's knowledge. The union did not have knowledge of the extent by which the proposed collective agreement would exceed the compensation envelope. The union did not have knowledge that there had been, that on the state's version, there was non-compliance with the various regulations. As far as the cost-cutting measures are concerned, if the state was of the view that the only possible way to make the agreement work was to introduce cost-cutting mechanisms, they were at liberty to put that on the negotiating table as a precondition to entering into the agreement or as a part of the agreement itself. It's not an uncommon thing in collective bargaining to say, you know, we can give you X amount, but we need to achieve this in savings and to quantify those amounts. The state chose not to do that.
Okay, thank you.
Mr. Orr, is it not part of the problem that the public service or government budgeting system is not synchronized with the wage negotiations? Already when there's budgeting, a provision is either made for salary increases or it's not, or it's a 0% that exists. And by the time when the negotiation starts, the trade unions already know that there's either there is a provision or not.
Well, my Lord, Justice Terletti, there is a problem in the sense of it creates a kind of artificial lag in the collective bargaining. It's very difficult to sort of imagine how one does it otherwise. But then it is really incumbent on the state to make it very apparent that these are the numbers and we don't have this permission and we don't have the following, and we need to put in place various measures to cut costs. And if you as the unions don't like all of that, then your right is to go to the streets and go on strike. And let us resort to power and let us see where that leaves us in due course. It really does not sit well that the state can say, well, in fact, what we'll do is we'll conclude an agreement which is unlawful. We will sit on that information until year 3 of that agreement. We have now insulated ourselves from a strike for 3 years. We've deprived certain employees of the right to strike and didn't even agree to the agreement for 3 years. And now we rely on this illegality to say, well, we're not going to comply with the final year of the collective agreement. That really is what the state is coming to this court and asking this court to assist them with, is something of that nature.
It might be so, but is it not really the real purpose of Regulation 78 and 79 to ensure that when there is this collective agreement, there's a realistic chance of the state being able to meet that agreement, and not to ensure that you get a collective agreement which has been reached perhaps for populist reasons?
Certainly, and that is a point that we make in our heads. We submit that those regulations are there actually for the protection of the trade union parties in the collective bargaining process, so that they can bargain and reach agreement with some confidence that the state will meet its obligations. And again, this is an issue that comes into play when one considers what the court should do in the event of a finding that there has not been compliance with the regulations, whether invalidity should follow or not.
So it would appear that what played in the minds of the CORM is the need to show that they are not negotiating in bad faith, and the other reasons that they have given them, which really are not covered by the Regulation 79. That should not be the reason to enter into a collective agreement.
As you respond, Mr. Or, the 40 minutes is up, but please go.
Certainly. If I can just indicate, I have only one point to make once I've dealt with Justice Tlaletzi's question. Justice Tlaletzi, I'm in complete agreement. The state has relied on improper reasons, as it were, to not comply with the regulations. The regulations are all about financial control. The state then says we're going to discard those regulations because we don't want to strike. And I mean, I'm making all these submissions to the court, obviously, on a finding that there hasn't been any form of compliance with the regulations. And again, this goes to the point of what does this court do if they find there has been non-compliance? Do they effectively condone the conduct of the state in jettisoning the regulations for, as you described them, Justice Tlaletzi, for popular reasons?
Thank you.
Mr. O, before you make your final submission, I just want to check with you briefly on estoppel. I know you've not dealt with invalidity because Mr. Maneche covered that. Do you accept as a general proposition of law that if the resolution is objectively invalid by reason of non-compliance with the regulations, then of course estoppel can't help you? Do you accept that as a general proposition?
With just a slight adjustment, Justice Majid, that's on the basis that the court finds that those regulations are not internal regulatory mechanisms.
Oh, yeah, of course. Yes. Yes. Thank you.
But we do accept. We accept if that if the court is against us on that, then we cannot possibly invoke estoppel or sensible authority.
Justice Madlanga, with your leave, is there any authority that you can present to us, Mr. Orr, that those regulations are internal regulatory mechanisms?
Unfortunately not, Justice Turan. I spent many days trawling the law reports on judgments dealing with the purpose of the regulations generally, the purpose of the PSA regularly, and particularly those regulations. I was not able to find any authority.
And on what basis do you make that submission?
I make that submission on the basis of the various contextual points that I have made in the heads. I submit that if one has regard to the other regulations and to the other sections of the Public Service Act, the indications are very strongly that they are internal regulatory mechanisms. That is covered in detail in the heads of paragraphs 81.
Thank you, Mr. Orr. Thank you, Justice Madlanga.
You're welcome, my sister. Yeah, Mr. O,
Justice
you
Madlanga.
said you have just one more point.
Yes, I think
time?
if you give me 5 minutes, Justice Madlanga, I'll be done.
Please go on.
If I can just wrap up. So most of the debate I've currently been having with the court relates to the question of validity. What do you do with a finding, having found that there's non-compliance with the regulations, having found estoppel doesn't apply, what do you do? And our submission is, for all of the reasons that I've currently debated with the court, a finding of invalidity should not follow. The final point I want to make, and it's one that's not really made by any of the other union parties, is what is the consequence of a finding of invalidity? And the consequence of a finding of invalidity is that the entire resolution 1 must be set aside. It cannot be that only clause 3.3 gets set aside.
Careful what you wish for, Mr. O.
I know this appears to be an argument that my clients would not be happy with, but they have mandated me to make this argument. It is quite clear that resolution 1 exceeds the compensation envelope from the moment of its inception. It is either unlawful in its entirety or it is lawful in its entirety. It cannot be that the court can simply say that clause 3.3 is invalid. The entire agreement would have to be set aside if it's unlawful, because it is otherwise the very point which the state is making, which is that you can't perpetuate, you cannot permit an unlawful situation to occur, is exactly what would occur, because every transaction made by virtue of resolution 1 would have been an unlawful transaction. And the consequences go further, because any future agreement that is made on the basis of salaries paid in resolution 1 would itself be invalid, because if resolution 1 is invalid, then we effectively have to go back to the position prior to the conclusion of resolution 1, way back to 2017. And I think it was a question from Justice Mahlanhla, which is, does that mean that everything would be up in the air? Indeed, that is exactly what it means. If this court sets aside resolution 1, which must follow, if there's a finding of invalidity of clause 3.3, then the entire collective bargaining structure of the last 3 years is laid waste. And we are basically back to the position prior to 2017. Those are our submissions. Justice Madlanga, thank you for the indulgence.
But then, as an interim measure, can't we impose a system of personal to holder until the whole situation is equalized, personal to holder?
If you could just explain that to me, Justice.
Say, to address the issue that you've just raised,
yes.
A system where we keep the salaries are kept at that level, personal to holder, until new negotiations take place and then come into place without collapsing the entire structure.
But that would then be saying, even though clauses 3.1 and 3.2 were unlawful, we're not going to declare them, we're going to actually single out clause 3.3 for a special treatment. I don't believe that is actually an option for this court. I think if the agreement is invalid, it's invalid.
Okay.
Unlawful, it's unlawful.
Thank you, Mr. O.
Thank you, Justices.
Thank you. Mr. Van Wyk.
Thank you, Justice Madlanga and the other justices of the court. As indicated, I appear for the 9th applicant, NUPSO, under case 44/2021. We have an application we filed an application for condemnation for the late filing of our application for leave to appeal. The application for condemnation is found in volume 19 on page number 1870.
Mr. Van Wyk, does any party object to that application?
The Treasury is
No objection.
Thank you very much. Thank you, Mr. Conlett. Please just leave that and make your submissions, Mr. Van Wyk. Thank you, Mr. Conlett.
As the court please, Justice Malanga. In terms of our application for leave to appeal, the court would have noticed that we've indicated in our application for leave to appeal that we support the submissions made, the factual background and submissions, both factual and legal submissions made by the PSA in their founding affidavit to the application for leave to appeal. Our situation is still the same, that we are in agreement with the case that has been advanced by the PSA in their founding affidavit and the legal submissions that has been made with regard to substantial compliance, also with regard to the issue of estoppel, which comes into play if the court should find that regulations 78 and 79 are internal regulations. We are in agreement with the PSA that the estoppel should then come into play under those circumstances. We are also in agreement with the submissions of the PSA with regard to the evidence or conclusion that can be reached on deviation by the minister of the DPSA, a conclusion that can be drawn from the circumstances of this matter. We, although as indicated by Justice Strong, that it's a matter that is raised for the first time in this court, we agree with the submissions by the PSA that it's a legal point, but it's based on the facts as appears in the record. I don't want to rehash everything that has been submitted by the PSA, but as indicated, we do not have a position any different to what has been advanced by the PSA in this matter. Unless the court wants me to go over everything again, but we align ourselves with the arguments and submissions by the PSA.
Thank you very much, Mr. Van Wyk. Any questions from my colleagues?
Yes, I do have a question.
Yes, yes, Justice Matondo.
Yes, Mr. Van Wyk.
Yes, Justice.
Mr. O, in his response with regard to whether it's only clause 3.3 is invalid or the entire agreement, he says the entire agreement should be invalid if the court finds so. What's your view?
I am in agreement, Justice Madondo. The LAC severed 3.3 from the rest of the agreement, and I am in agreement with Mr. Orr that one cannot sever 3.3 from the rest of the agreement. It is part and parcel of the same agreement, and any declaration of invalidity will affect the agreement as a whole.
But the Minister of Public Service says that all the requirements for clause 3.1 and 3.2 were complied with, the money was available, so there's no problem with them. So according to the minister, all the formalities were complied with. So on what basis can now be said it is invalid?
Justice Madondo, if one looks at the breakdown, and Mr. OSC has alluded to that, the breakdown over the period of the 3 years, that the compensation envelope was already exceeded in the 3.1 and in 3.2 and in 3.3. So the amount that the compensation envelope is exceeded by is an amount that is an amount combined by 3.1 and 3.2. So the 30 billion is made up of what is exceeded in 3.1, 3.2, and 3.3.
Yes. But was it not an indication that only 3.3 could not be covered, but the 3.1 and 3.2 will be covered? And in that way,
if 3.1 and 3.2 had already exceeded and it could be covered, it brings me back to the point that was made that at the stage when government entered into the agreement, government had accepted that the agreement would be affordable in terms of 3.1, 3.2.
if 3.1 and 3.2 are covered, it means that the formalities have been.
Justice, due to the fact that it would still be exceeding the compensation envelope, 3.1 and 3.2 would still be exceeding the compensation envelope, then it will suffer from exactly, in my respectful submission, exactly from the same defect, if one can call it that 3.3 would have suffered from.
Justice Madondo? It looks like you're muted, Justice Madondo. Yes.
My problem with the that would not mean that whatever the members of the union received had no legal basis, then they have to pay that back.
Which would lead to a nightmare. With and I think the PSA has made that point as well, that it would lead to a nightmare of government then suing each and every public servant for an overpayment on their salaries. And it would lead to an untenable situation.
Okay. Thank you, Justice Madanga.
You're welcome, Justice Madondo.
Thank you, Mr. Van Wyk.
Thank you, Justice Madondo.
Thank you very much, Mr. Van Wyk. Thank you.
Thank you.
Yes. Mr. Brainders?
Thank you, Justices.
I'll just remind colleagues that Mr. Brainders said we may interrupt him right from the beginning. You may start, Mr. Brainders.
Thank you. And of course, we invite interruptions from the word go. We're going to deal with three questions. Jurisdiction, delay, and remedy. The other questions we will leave to our colleagues from the National Treasury, and they will deal with that. As to jurisdiction, it appears to me, listening to the debate that the court has had with our colleagues for the unions, that it's going to be difficult for me to persuade the court that it doesn't have jurisdiction. We've made the submissions on jurisdiction in our heads, and what I don't want to trawl through them, and I don't want to spend too much time on this if the court is inclined to allow under jurisdiction to hear the matter. But I do want to point this out. The question under jurisdiction is there a constitutional issue that engages the court's jurisdiction? That's the question. And we say that under UCT and Nahawu, we're not dealing here with an application to set aside the regulations, nor was there any serious debate at the LAC about the meaning of the regulations or its application. In fact, there wasn't any today either. So it's not on that basis that your jurisdiction is engaged. In relation to 23.5, which is collective bargaining, I just want to point this out. It's true that in their affidavits, there was a reference to collective bargaining, but the dispute before the LAC was never, how does Regulation 79 implicate the right to collective bargaining? In other words, it was never which of the contents of collective bargaining does Regulation 79 interfere with. That was never the debate. And if that wasn't the debate, then we say, well, then jurisdiction isn't engaged in relation to collective bargaining and 23.5 of the Constitution. And then the last point we want to make is on jurisdiction is it's true that SATU in the affidavits raise this good faith bargaining point, but there's no objective evidence of bad faith bargaining. And in that regard, can I almost straight away answer a question that was asked by, I think it was Justice Madondo, if I'm not mistaken. And what Justice Madondo asked was, well, what did you know at the time of the conclusion of the agreement? And I'd like to refer you to the minutes. Give me a moment. So the minutes is that's the minutes of the PSCBC meeting. And at page 369, I think it's volume 4, 369, you have part of the minute of 3 May 2018. And at the top of the page, there's a reference to 2415 on 4 May 2018. And then there's a caucus. I hope that all the justices can see that. And then after the caucus, the employer indicated that they would also be tabling 4 major issues in council shortly: review of performance bonus, review of the ASD, voluntary severance package, and reconfiguration, which would also impact on the fiscal allocation. They implored Labour to reconsider their response on all matters as their tabled revised offer was their final mandate. Then Labour makes an inquiry, and the employers said that Labour's proposal puts them out of their fiscal space. Labour wanted the employer to quantify the fiscal space. The employer replied that their revised offers had forced them extend over 32 billion rand, but with Labour's latest proposal, that would be further extended. Labour then requests the employer to take a caucus, and further down, the employer requests a caucus, and then after the caucus, the employer presented the figures indicating that they had gone 30.2 billion rand over the 110 million originally earmarked in terms of the cost of living agreement. That's on the morning of the 4th of May, 2018. If you then go to page 373.
Of what volume, Mr. Brenders?
Same volume 4. Forgive me, Justice, volume 4. 373, second paragraph. And this is, if you could turn to 371, you see it's a continuation of the meeting on 15 May 2018. And then at 373, the employer thanked Labour for their input. They requested a caucus. The employer, however, reiterated that the offer they tabled on 3 May 2018 and the draft agreement of 4 May 2018 had already put them to more than 32 billion rand over the budget. They did not want to create the expectation that the budget could be extended further. Now, I refer you to those parts of the record for two reasons. The first is to show you that the allegation that the employer was negotiating in bad faith isn't supported by the objective facts. And the second reason I refer you to that is to illustrate, particularly to Justice Madonda, who repeatedly asked this question. And all our colleagues from the unions either said, well, we never knew at the start, this was only told to us much later, and we didn't know the exact figures, and we didn't know precisely what the extent of the problem was. They either didn't reacquaint themselves with the record before this appeal, because what they say is completely inconsistent with the objective evidence. That is, the PSEBC, everyone knew that the agreement which the union wanted the employer to conclude was 30.2 billion over the approved fiscal budgeted ceiling. So there's no negotiation in bad faith. And so on that score, we say that your jurisdiction isn't engaged on the question of collective bargaining.
Sorry,
However,
Mr. Branders, there might be a question of bad faith if this, or at least recklessness, if what you've read to us seems to be conveying we're happy with the 30.2 billion, but don't try and push us beyond that.
No, that's not what it's saying, because we know, and you already, Justice Rogers, earlier referred to the mandate. And if one reads this together with the mandate, then it's clear that the ceiling was hard. It was 110 billion.
But
and
isn't
what was
that part
sought,
of, sorry, I was interrupting you. Carry on.
we say if you read the two together, then the employer didn't suggest that concluding an agreement for 30.2 billion over the approved budget was possible.
What is the evidence? Is that document where I read the bold footnotes at the end of it, the mandate, was that a document given to Labour?
Yes, it was tabled at the PSEBC. In other words, well, that certainly was the mandate, and my understanding is that that was tabled, but that's my understanding, but I've asked my junior to check.
If you can just check the evidence, because to say that the minutes must be read with the mandate presupposes that whoever was talking for government at the bargaining council was conveying that limitation. And as I read the passages of the minutes that you've read to us now, they were actually, the government negotiators were promoting the deal that was ultimately adopted with its 30.2 billion excess and telling Labour, you really can't expect more.
Yes, but the point is that they're saying it's 30.2 billion in excess of the approved fiscal limits.
Yes, but what they are not saying is that the government has not done what is needed to make sure that we can achieve that. They aren't saying we can't even do the 30.2 billion.
That's true. But the question is whether there is approval or not is an objective question, and you've got to determine that.
That I accept, but we were the subject of the conversation was the government playing open cards with the unions in the bargaining council, and it seems to me there was not a complete symmetry of knowledge.
Well, we say they were because, of course, I did refer you earlier to that passage where they talk about the introduction of what are the cost-saving measures. So there's a passage earlier on the 4th of May where they say we are going to be tabling these, we're going to be tabling an agenda including these measures which we have to introduce. So we say that if you read, let's assume for the moment that the document containing the mandate wasn't tabled. Then what you left with is the minute. And we say if you read the minutes in its entirety, you can't deduce from that that government was playing fast and loose with the unions, because they say we're going to have to introduce these cost-saving measures, and they say we're 30.2 billion over the fiscal limit.
Mr. Brendan, I'm moving to something else if my brother Rogers is finished.
Yes, I am.
Thank you. And if I'm taking you out of your stride with jurisdiction, please say so, Mr. Brendan. Then I'll pause for you to first finish that, because this is something else. I'm moving on.
No, you may move on, Justice.
Thank you. Mr. Brandes, much has been made by the applicants about the fact that the employer raised the question of non-compliance late in the papers only in answering papers. Now, what are we to make of that complaint? Because it seems to me that invalidity is an objective question. Does the bona fides otherwise of the respondents of the employer come in here? And B, is this a Gijima type of situation which some of the applicants rely on? What is your take on that?
No, Justice, it is objective, and you are right. The good faith or otherwise doesn't matter. We either comply with the requirements of 78 and 79, or we don't. So good faith doesn't come into it. And then you really are moving into the question, I suppose it's a combination of delay and remedy. So let me very quickly move on to delay, because partly this answers, together with remedy, this answers your question. So on delay, the question is there scope for interfering with the jurisdiction, I beg your pardon, with the discretion exercised by the LAC? So as we know, this court and the SCA have confirmed that the exercise of a discretion to grant or refuse condonation is a narrow or quasi-narrow discretion, and there's limited scope for interfering with that on appeal. You can if it's decided on a wrong rule of law, or if the court below is mistaken on the facts. Now, here what happened was that the LAC considered itself bound by a judgment of this court in Khumalo. We submit that it was correct to do so. Khumalo does apply. And when it applied Khumalo, it said what it was dealing with here was the question of delay in the context of the government contending for unlawfulness and invalidity, for non-compliance with the requirements, the statutory requirements laid down by the regulations. In a case like that, the LAC said, well, Khumalo says you don't need to apply formally for condonation. Well, if you don't need to apply formally for condonation, you don't need to set out all the requirements in a condonation application laid down by...
Mr. Brainers, we'll take a lunch adjournment now and resume at 2:05.
So, please.
Court will adjourn until 2:05. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 2:05. Should you exit, you may use the same link to rejoin the hearing.
Justice Madondo, are you with us?
I don't think Justice Madondo is with us yet, Justice Madlanga.
And Justice Throne, is he the only one missing? The only colleague, or there he is. Justice Chikri.
Justice Mklantla, I don't see Justice Mklantla, Justice Madlanga.
She was on here just now.
Oh, Justice Mklantla is with us.
Thank you. Mr. Brainders, please continue. You are muted. You are muted, Mr. Brainders.
Forgive me. Before the adjournment, we were dealing with delay, and I submitted what the test was, and we submit that on the test, there is no scope to interfere with the exercise of the LAC's discretion for these reasons. What the LAC found was it was faced with a delay in the face of legally invalid conduct plus the public interest. And it found that in the face of invalid legal conduct or legally invalid conduct and the public interest, which it described as massive, in the judgment, it's described as either 30.2 or 37.8 billion rand. In the face of those two considerations, legal invalidity and public interest, the court decided, the LAC decided to condone delay. We submit that on that, the Constitutional Court should not fault that approach because there's little to fault it with. I mean, those in a case.
Mr. Mukari said, other than the billions, the rest is extraneous matter.
Except that,
or at least, I hope I'm not exaggerating, or at least part of it is extraneous matter. What do you say to that?
Well, I'm not sure. I can't recall what precisely he was referring to, but it's not extraneous matter in the LAC when faced with what to do about delay, to ask itself what to do in the face of legal invalidity and public interest, and in this case, huge public interest. Those are clearly considerations that are not extraneous, they're relevant, they were raised on the papers, and the LAC was not only entitled, but it was right of it to take into consideration those factors. And on the basis of those factors, it found that it was proper to condone the delay.
Brenda's, Mr. Maneche laid emphasis on the fact that, according to him, the LAC did not consider at all whether the delay was unreasonable, and he cites the passages from paragraphs 26 to 31 of the judgment in volume 16, pages 1588 and onwards. What do you say about that? He says that's not a judicial exercise of the discretion by the LAC.
Well, it's true that the length of the delay is relevant. But remember here, on the facts, the objective facts, and can I just remind the court very briefly how this agreement works? So it's true that in 2018, they conclude this agreement. It's a 3-year agreement, and it provides for many things, but clauses 3.1, 3.2, and 3.3 provide for annual cost of living increases for the 3 years. By the time the application was launched in April of 2020, that was last year, the So if you look at the agreement, it says the agreement is for each of 3 financial years. And in the government, financial years run from April to March. And we know on the record that between February or March and May of last year, that was last year, the government was still engaged in negotiations in trying to, at the PSCBC, in trying to get the unions to change its stance. And its stance was all of 3.3, enforcement completely, and that's what we want. The government at the PSCBC, even as late as last year, was trying to get the unions to step off, as it were, that fairly big demand and to accept something, to come to some sort of compromise. And remember that they said that they could, from within the budget, they could reprioritize, and there was 13 billion available, and they tried to get the unions to accept, as it were, a sort of compromise. And the unions disagreed. Now, when one looks at delay, one must look at it in the context of the government saying, first we tried the cost-cutting measures after the agreement was concluded. That didn't succeed. We tried it over 2 years. That didn't succeed. And then we tried before 3.3 is meant to be enforced, because it's only due for enforcement in 2020. Before it's enforced, we tried to talk to the PSCBC. They simply refused to talk to us. That, might I just add, is in line with their attitude taken at the PSCBC during January to May of 2018. It comes back to the question of good faith bargaining and what happened at the PSCBC, but at page 145 of the papers, so it starts at 144, the May meeting, then there's the presentation, and then government's attempts to present the presentation. That's at page 146, 3 May 2018 PSCBC meeting. And it says, the employer returned to the PSCBC with the presentation based on the presentation by National Treasury on the economic outlook. The negotiating team asked to go through the presentation, and then over the page, the unions refused to listen to the presentation, stating without having seen it that it was the same one they had rejected earlier. So far from is the accusation that government acted in bad faith. Far from government acting in bad faith, it tried to engage with the unions at the PSCBC to attempt to show them what the problems were initially. And then when 3.3 is due for enforcement, and remember it's 3.3, so the agreement is invalid. You'll see later on remedy. No quibble with that. The problem is that 3.3, the cost of 3.3 takes it over the ceiling. And at that stage, government says, we can't do this because we're going to, if we enforce it, we're going to breach the ceiling, the approved ceiling. And so it says, we can't do that. Can we try something else? And the unions refuse. So it's in that context that you must look at an unreasonable delay. It's not that they stood by and did nothing and let this thing run. They tried the cost-cutting measures. They tried a compromise. And when the union sought to enforce, they said, well, there's this problem with invalidity. There is this problem with the hard ceiling. So in that context, the LAC, we submit under delay, takes an approach which would be hard to interfere with under the test. So much for delay. Can we get to remedy? And on remedy, this assumes, and you'll hear from Mr. Gauntlet, this assumes, of course, that the agreement is invalid for want of compliance with Regulation 78 and 79. What the LAC does is it makes a declaration in its order of invalidity. The question then arises, well, what does it do under remedy? Now recall that on the papers before the LAC, the unions had taken the very simple position, or shall I say simplistic position, which was there's an agreement or there's a collective agreement, there's a provision in it, clause 3.3, you must enforce. They never suggested on the papers anything less than full enforcement. So what faced the LAC was the unions, in the face of invalidity, on the papers, having made out a case for full enforcement and nothing else, and governments on the expectation that the court might go against it, putting up information to illustrate that if the agreement is found to be valid, it would be unjust and inequitable to enforce, if the agreement is found to be valid, I beg your pardon, it would be unjust and inequitable to enforce clause 3.3. And then it sets out all those reasons: discharge of its constitutional obligations and the public interest and the prejudice to the fiscus. It sets all of that out. That's what faced the LAC. And when it was faced with those papers, it said, well, in argument, the unions say, well, why don't we try a staggered approach? And they say, but we don't know how a staggered approach is to work because there's nothing on the papers that helps us to determine whether a staggered approach is just and equitable and how it might work. And so then it says, on that basis, all we can do, if it is declared invalid, is not to enforce clause 3.3 because the agreement is invalid. Now, where did that leave the unions? Might I just point this out? Where that left the unions was here. The only thing they didn't get out of that agreement was the increase for the last year under clause 3.3. Everything else they got. Every other aspect of the agreement was implemented. In fact, as late as last year in July, in the height of the first wave of the pandemic, during March to July, it rejects the proposal by the employer to try and reprioritize funding by cutting or by reducing the pay progression, those performance-based increases, and in particular. And there was one other area where they said that I think it had to do with when people left the service. There was they could reprioritize funding there. In the face of that proposal, the union said, no, well, you've got to enforce 3.3 fully. In July, in the height of the first wave of the pandemic, the provision on pay progression, performance provision, in other words, performance increases under pay progression, is implemented. And in the reply, government, the DPSA says, after that, there was no more money left. We couldn't prioritize funding within the budget to make anything available for something less than full enforcement. So these are employees who got everything under the agreement. All of that, by the way, DPSA says, fell within the fiscal limits, fell within the ceiling. Clause 3.3, or the enforcement of clause 3.3 was the problem. And if you had to enforce it, well, we then exceed the fiscal limits. Which we don't want to do. And so under remedy, when we can't confuse validity with remedy, under remedy, what the court was faced with was, the LAC was, in anticipation that the court might order that the agreement is valid, it's got all the information from Treasury and DPSA, and that information says huge prejudice to the public interest and to the fiscus, particularly during an economic downturn and a pandemic, in which there's an even greater need to discharge its constitutional obligations to the poor and vulnerable. Nothing from the unions. And the LAC says, well, insofar as you make a suggestion in argument to the LAC that we've got to do something less than full enforcement, we don't know how that would work because there's no evidence to show us how that would work. And we submit that in the exercise of that discretionary, or in the exercise of its discretionary remedial powers under 172(1)(b, again, what's to fault about the order where the LAC says invalid, decline to enforce? We submit that should you cull through the papers, you'll find that the LAC was correct, that it was left with no option but to adopt the information put before it by government and not to enforce clause 3.3 and not to grant anything less than enforcement. Those are submissions.
Justice Madlanga, if I may put a question to Mr. Brainders, with your leave.
Yes, Mrs.
Thanks. Mr. Brainders, the mandate, could you explain the mandate to me, please? It appears that it could be contradictory. On the one hand, it says that an amount of 30 billion is mandated. On the other hand, it says that the offer does not inject any new funds into the current personnel expenditure over what has been budgeted for, and that the state will ensure that the personnel expenditure ceiling is maintained.
Yes. Justice Turon, that's what it says. And in fact, it gives the figure. It says the ceiling is 110 billion or the envelope is 110 billion. And we submit that, I think, Justice Turon, respectfully, you construed in a debate with our learned friends that that was a conditional mandate. In other words, you can conclude it.
I was postulating, Mr. Brainders.
Well, forgive me, that I said respectfully, I was clearly wrong. So on that postulate, we submit that, Justice Turon, your postulation is in line with a coherent and sensible interpretation and application of the wording of the mandate.
Is there a possible contradiction in the mandate?
No.
Subject to cost-cutting measure.
It says you can conclude subject to cost-cutting measures and subject to no further injection of funds and subject to the ceiling, which is 110 billion.
Yes. We're indebted to your junior, Mr. Brainders.
So am I.
Any question? Thank you very much, Mr. Brainders.
Yes, sorry.
Yes, yes, my brother, Justice Mabendo.
I do have a question. Mr. Brandel, where is he? I don't see Mr. Brandel?
He is there, my brother. He is there. Just pose your question. He'll hear you.
Oh, not disappeared. Let me understand the position of the state in this case. What is the failure of the state to meet its obligation in terms of clause 3.3 due to the illegality of the agreement in question, or is due to the unfordability?
Invalidity. But remember that regulations 78 and 79 are focused upon what is fiscally affordable. So they say, or their purpose is that government does not conclude collective agreements that for which there is no approved budget, or for which there is no, there are those three conditions, but essentially there's got to be approved budget, or there's got to be a written approval by, approval by National Treasury. Now, the purpose of those regulations is to ensure that the state acts fiscally responsibly and it acts within affordable limits. But the reason for invalidity, or the reason why the state asked for the declaration, was not because it couldn't afford it. Principally, it said it's invalid. When it comes to remedy, there is no money.
Well, I'm having a problem in that, because in the state's correspondence with the unions, it only indicated the unaffordability. Even at the time when the state was asked to make the presentation before the PSCBC, it didn't talk about anything about invalidity. The invalidity only came to the fore at the time when the matter was about to be referred to the LAC. So then I have a problem that if that was the prime reason, why should it not be communicated to the unions right from the outset?
So the people at the PSCBC are not lawyers, and it's true that they didn't use words like invalidity, but what they did say was that 110 billion was the approved budgetary allocation for the payment of compensation for the bargaining unit. And we submit that that shows that the state was aware that it was limited by approved budget or by National Treasury approval, and it conveyed that to the unions.
So when did the state become aware of this invalidity?
Well, it doesn't matter. It's invalidity is objectively determined.
Yeah, when it became aware of it.
But the question is the awareness of government relevant to the question of invalidity or not? And we would submit it's not.
It's
so it doesn't. Well, it doesn't matter whether they knew at the beginning, in the middle, or at the end. If it's invalid, it's invalid.
Yeah, it matters because that should have been communicated to the unions, and then this dispute also can be referred for for resolution on that basis.
Except that we do point out, with reference to the minute and with reference to the affidavit, that what government said to the union at the PSCBC was that 110 billion was what was approved. That was the approved budget for the compensation for the bargaining unit. And it's not as though government was talking to level 3 or 4 employees. They were talking here to the negotiators of all the unions at the PSCBC, the bargaining unit for the state, and at which it bargains regularly. It wasn't the first agreement it had concluded.
So how did the question of cost-cutting measures come into picture?
Well, that's the conditional mandate. In other words, the mandate from Cabinet was you can conclude the agreement, but subject to cost-cutting measures so that you bring it within the hard fiscal ceiling of 110 billion. And we showed you that at
that was the duty of the government. So.
Yes, but at the meeting of the 4th, remember, at the meeting of the 4th, we referred you to that passage where government says we want to talk at the PSCBC about cost-cutting measures. And there's not only one, there are a number, I think there are 4 of them. And the government says in the affidavit that the unions were not interested in negotiating, in talking about cost-cutting measures. That's not disputed on the papers. And we know that when they tried to implement cost-cutting measures, the unions opposed it.
Okay, but were the unions aware that the agreement was somehow conditional?
The employer says that, I just correct something that I think one of the justices asked earlier. So the question was the mandate tabled, that particular mandate referred to from Cabinet? It does not appear that that document was tabled at the PSCBC, but government says that on the papers, it says that it informed the unions at the PSCBC that they could only conclude on the strength of cost-cutting measures, which is why they wanted to introduce those at the PSCBC, and they say what they are. Reduction in headcount, reduction of bonuses, reduction in the OSD, I think occupational services dispensation, and there was a fourth, it escapes me now, but that's all in May of 2018. That's on the table. The state puts that on the table.
What prevented this condition from getting into the contract or into the agreement itself?
I say the unions refused. The unions refused to sign on their basis.
And the state signed on the same basis.
Well, the state signed. DPSA says they signed knowing that this thing could only be on the basis of cost-cutting measures. They say they asked the unions to include those or such a provision in the agreement. The union refuses. But yes, they signed it on their basis.
So why did the state forge on with the signing on the face of the union refusing?
Well,
to accept this condition?
Because they thought that they could get the unions to agree. See, they tried. When they put it on the table, they tried to implement the cost-cutting measures. The unions refused. They went as far as last year to talk to the unions about a reduction to bring, at that case, not to bring it within the hard fiscal limits, but to say you can't get enforcement, but we can give you something else by reprioritizing the approved budget. That's less than the 29 billion. It's now been recalculated by National Treasury in this application. But they say you can't get the full 29 billion, but we can find 13 billion. The unions refuse. So the unions were never interested in anything less than full enforcement of 3.3 and getting the equivalent of the 29 billion.
Okay, thank you.
Justice Ron has one
Justice
more. You're welcome, my brother.
Thank you very much. Thank you very much, Justice Madlanga. Mr. Brainders, if I heard an earlier submission of yours correctly, it was that it's clause 3.3 that takes us over budget. Is that correct?
Correct.
I'm not sure I understand that. And so if we look at page 1584 in volume 16 of the record, and it also summarizes the presentation, and this also appears in the presentation. Line 2 says, in order to obtain the additional funding necessary to meet the costs of the collective agreement, including 3.3. I have not heard it previously been suggested that the additional cost for the first year of 6.2 billion, the second year of 10.7, and the third year of 13.2 was only in respect of implementing clause 3.3. And I may be wrong. My understanding was that the additional cost to fund the entire collective agreement would be in excess of 30 billion.
What the DPSA said in the papers was that the cost of implementing clause 3.3 would amount to, well, that's now 29 billion. That's the cost of implementing clause 3.3. That's
And
what they
is
said.
that in line with the presentations that were done?
Well,
or is this a cost that was later calculated?
No, because we now know what the cost. Remember, these were the presentations at the time. So what the judgment refers to is the calculations at the time. But
now this is my question. The projections at the time when the presentation was made and the cost, the additional cost of 30 billion, that was not presented on the basis that it was clause 3.3 alone that would necessitate or incur the additional cost. As I understand the presentations were that the cost of implementing the entire collective agreement would incur an additional 30 billion.
You're correct, Justice Theron. You're quite correct. In other words, the agreement was over 30 points. The agreement exceeded the fiscal limit by, at that stage, 30.2 billion. We now know it's 29. What the DPSA said, though, is up to now, we've kept within the fiscal limit. If we have to implement clause 3.3, the cost of the implementation would be 29 billion. In other words, if we implement clause 3.3, that takes us currently over the fiscal limits. And remember, what they're doing is they're implementing an agreement over a 3-year period. At this stage, they haven't yet, well, last year, they hadn't yet paid the increase. And they said, if we have to pay that increase, that's what it's going to cost us so much. It'll take us by so much over the limit. But you're quite right, Justice. At the time, when they concluded it, they didn't say a separate clause would exceed the agreement by 30 billion. They said the agreement is exceeded by 30 billion.
On that basis, how can we sever clause 3.3 from the agreement, the rest of the agreement, or the resolution?
In fact, the LAC didn't sever it, and we don't seek severance in the appeal. We say the LAC was correct to declare the entire agreement invalid, but not to enforce clause 3.3.
That means clauses 3.1 and 3.2, which are invalid, have already been enforced.
Yes, implemented.
And implemented, and nothing will happen with that.
Correct. Same as in Asla and Buffalo City. Same as in Kajima. You've got, well, not exactly the same, but similar. The agreement has been implemented, 3.1 and 3.2, and all the other clauses in the agreement, all the other provisions have been implemented. And the cost has been carried, and it's been carried within budget. The only thing that will not be implemented is the cost of enforcing the annual increase for the 3rd year.
Thank you, Mr. Brainers. I'm indebted to you as well, Justice Mdlanga.
You're welcome, Justice Theron. Thank you very much, Mr. Brainers. Thank you. Mr. Gauntlet.
Thank you, Justice Madlanga. May I at the outset apologize, like several of my colleagues, I haven't been able to achieve what is termed in the protocol a perfectly blank or neutral background, but it seems to be a consequence of the Zoom connection for us today. Justices, in the light of the very full debate that has happened, I shall seek to try to focus our oral argument on really addressing 7 questions. The first is to identify clearly what the case was which the unions brought. The second is whether clause 3, particularly 3.3, but in the light of particularly the clarificatory clause 3, had to comply with regulations 78 and 79. Thirdly, did they comply? Fourthly, if the clause 3 didn't comply, or rather if the agreement didn't comply, whether invalidity is a consequence. The fifth is whether the unions are entitled to base their case now and it really goes back to my earlier point on section 23 of the Constitution. The sixth is the argument really by our learned friend, Mr. Makari, that if the court holds the agreement invalid, can it use its wide powers under section 172 nonetheless to preserve it? The last deals really with the issue of remedy, although I shall also touch briefly on the issue of delay. Justices, the case the unions brought was very squarely and by choice, as they put it, simply contractual. We've gathered the references for you in footnote 44 of our written submissions, paragraph 20, and I won't repeat those. The suggestion was that because the case was brought in contract, they stood free from the constraints of constitution and public law. Since there's been a significant shift, as you've heard, to an attempt to rely directly on section 23 of the Constitution, and I shall pick up on that. Turning to the second question regarding whether the agreement had to comply with regulations 78 and 79, our submissions will be brief. In a series of probing questions, members of the bench have taken our learned friends to the wording of regulation 78 and 79. And as you know, it's also replicated in several sets of the heads of argument. May we just make these points? First is, Treasury was rightly joined as a party by the unions because they identified that Treasury had a particular interest of its own separate from the department in the proceedings. Why is that? It was touched upon, I think, by one question of one member of the bench, and that is section 216 gives a particular and important constitutional obligation which must establish a national treasury, etc., to ensure both transparency and expenditure control in each sphere of government. So it's a government department, yet it stands alongside other government departments in a particular watchdog capacity. And that was recognized by this court in RTMC versus Waymark, Infotech 2019-5 SA 29, Constitutional Court, in paragraph 49. So it has a particular interest in the proceedings, and I'll come to that later, because one of the questions, for example, in relation to delay has been when Treasury got involved, has it delayed? Is there any conceivable argument or case in relation to delay pertaining to what it did? So as regards 78 and 79 themselves, we submit that the important aspects are these, that there are very stringent expenditure and transparency controls, to pick up in the language of section 216 of the Constitution, in regulations 78 and 79. Justice Rogers highlighted some of the aspects in particular in his questions. And when there is, for example, as there is in section 101 of the requirement, in that case in relation to the president, that decisions be in writing, it's not for reason of formalism. It's because it's a very important restriction and constraint, and to make sure that there are not arguments about what or was not actually authorized. So we submit that the provisions of section 78 and 79 are very clear. And as we submit, our learned friends were driven to answer in a series of questions by the bench. It is clear that they were not complied with. they are unable to point to particular documents which would reflect the written compliance with 78 and 79. But that brings me to my next point, and that is that it was argued as to whether they complied, that they did, and our learned friends had to increasingly turn to substantial compliance. Might we just remind the court that shows everybody's age, because substantial compliance is what we all used to argue, but this court made it very clear in ACDP versus Electoral Commission, 2006-305, paragraph 25, and in All Pay 1, 2014, 1 SA 604 at paragraph 30, that actually there's one question, compliance. And some statutes require what you might call strict compliance, but one shouldn't get involved in these adjectives. You should look to the purpose of the statute and ask if the purpose is defeated, if there is a degree of generosity or slack which is allowed in the issue of compliance. We submit here that the setting makes it very clear that it isn't. Why? Because the mandate comes from section 216 in the Constitution itself. 2, it concerns financial compliance. It concerns the watchdog role in particular of Treasury. That 3, that purpose would not be served if one could say, well, there wasn't actually written compliance, but I sort of did a drawing on the back of the menu, or I did discuss this with that minister, and there was this particular form of compliance. It means what it says. And in this regard, may I deal with another major flaw we submit in the argument you have heard from our learned friends for the unions, and that was put at its apotheosis, I think, by our learned friend, Mr. Makari, when he said, Cabinet is the highest decision-making body. Now, if it is so that the answers given to Justices Rogers and Turon highlight the fact that there can be no indication of actual compliance with what our learned friends have to lift themselves above and say, if Cabinet approves, then that constitutes or is sufficient compliant with 78 and 79, because Cabinet is the highest decision-making body. The problem is this, Justices, that the Constitution differs in as to whom it vests particular powers in, and so do statutes. For example, the Constitution will say that the President must appoint heads of Chapter 9 institutions, and indeed of the judiciary itself. Now, the fact that somebody produces proof that there was a Cabinet discussion in which X or Y was approved as Chief Justice, and sitting in Cabinet happened to be the President, would actually not, we respectfully submit, be compliant. Why? Because as in granting a pardon or appointing one of those officers, it is vested in the President alone. Now, some people would say, oh, the greater includes the lesser. This is a very technical argument. The President is sitting there, and in this case, the then Minister of Finance was sitting there. But the separation is for very good reasons. There should
Mr.
not be...
The 10 minutes is up. You may continue.
Thank you, Justice Madlanga. Thank you very much. The distinction is this, that it is something which should be done by the particular office bearer alone. He or she should not sit in a Collective OM or in Cabinet. And there's a vigorous discussion, and by substantial consensus, maybe a decision is taken in one direction or the other. These powers are often lonely powers, and the probity and the safety lies in the fact that a designated office bearer carries the can, or as President Biden said last week, the buck stops with him. It's got to stop with somebody, and we submit that Regulations 78 and 79 do not permit this argument that there was a discussion in the COM or there was a discussion in cabinet. They're very specific. They have to be interpreted to uphold the probity and the safety of the decision, and they say what they mean. And if that is so, justices, we submit, then the stark position one arrives at is that there was no compliance with 78 and 79. Now, Justice Madondo has explored the question as to when this was known. And in fact, I'm sure our learned friends will confirm, all this takes us off the papers. But what is important is that when matters started to proceed to the bargaining council and Treasury was brought in on short notice as a party, then at that stage, 78 and 79 were put into play. I don't want to testify or go further than that. It is that it is quite correct that the unions were not alerted in earlier stages of negotiations, etc., as to regulations 78 and 79. As Mr. Brainders has explained, the department is represented by negotiators, professional consultants, and others who unfortunately do not always carry the constitution or the regulations in their heads. So the point is that they may not have known, but to that, as Mr. Brainders has asked the question effectively, so what? As a matter of objective legality, the necessary legal authority hadn't been established. And as so often happens in litigation, it is at the moment that the air is thick with gunpowder that other eyes look closely at provisions and say, but did they comply with this? So the essential point then is that there wasn't compliance with 678 and 79. If there wasn't, then the question arises, what are the consequences of that? We respectfully submit, for the reasons which we've addressed at length in our written submissions, that the consequences in principle.
Mr. Consulate.
Yes, Justice.
Can I ask you to factor in the debate that we are getting into the question that I had asked from Mr. Maineje. I know that you promised to come to section 23, but you're dealing with regulations 78 and 79, yes, and the validity as well. So I will leave it up to you as to when and how to deal with that. It's basically a legal principle. Yes. What I'm asking is that the basis of the invalidity is a regulation. That is now regulation 79. Right.
Sorry.
If we look at the fact that a regulation is subordinate to a provision of the statute, in this instance, I would say section 23. And when I look at the answering affidavit, at least of Gaynosa, they refer to section 23. And then they refer to section 23 and 32 of the Labor Relations Code. I think my problem really, and what I'm getting to, is whether the provisions of the Labor Relations Act should or should not trump the regulations.
Before you respond,
yes, I'm indebted.
Mr. Conlet, before you respond, I forgot to alert colleagues to the fact that there is an echo with Mr. Conlet's device. Even with the assistance of Mr. Naidu, the problem could not be resolved. So, colleagues, let's just live with it.
If I may just ask one question, please, Justice Madlanga. Mr. Gauntlet, is there only one device in operation in the area where you are?
There is, and we even switched off some Bluetooth device, and I'm ready to switch off my lights if needed, but I don't know why, Justices.
One point, Mr. Gauntlet even asked the people he was with to go out with the devices they have, and the problem still remained, Justice Theron.
Okay, thank you. Thank you, Justice Mdanga.
Thank you.
I apologize,
Yes, Mr.
Justice
Gauntlet.
Theron and other justices. I can only try and achieve some brevity, but if I'm totally inaudible, would you please stop me? May I return then, thank you, Justice Theron, to Justice Cheeky's question. The direct answer we would give is this, that the court recalls that the LRA, like some other statutes, PADGA and PIA, etc., which are very much children of the Constitution, mandated by the Constitution, often, or not often, but those statutes have a trumping provision, such as Section 10 of the LRA. We submit that nobody has pointed to what in the LRA comes into conflict with 78 and 79. 78 and 79, they're regularly saying that you can have what agreements you like, but as regards financial provision, these are requirements for them. That's all they do. They are an important financial add-on, if one likes. So we respectfully submit there's no question of a conflict such as would trigger the need under Section 10 to say that the LRA triumphs over Regulation 78 and 79. Secondly, while I'm answering Justice Cheeky's question, may I just pick up on this point of the enthusiasm with which Section 23 of the Constitution has been embraced. First of all, our learned friend, Mr. Makari, quite correctly told the court that this ambit of Section 23 was ventilated before the LAC. But the LAC may well have decided, together with looking at the heads of argument and including my learned friends before that court, but the LAC may well have decided in relation to Section 23 of the LRA that, no, the section of the LRA. Sorry, I thought, oh, sorry, of the Constitution. Yes, that the important thing to note is that what it says in the second sentence is that national legislation may be enacted to regulate collective bargaining. So one, on principles of subsidiarity plus the, in this case, express wording of 23.5, one would have to point in the LRA itself is contended to be in conflict and require to trump. Lastly, may we ask you to see how this reliance on the on Section 23 slid into the case. You will find in the answering affidavit, as Justice Cheeky points out, it's in the answering affidavit at 1334 in paragraph 29, where this is the pleaded contention. The legal recourse sought to enforce the agreement is simply made to ensure that the employer honors the agreement which was concluded under the banner of the right to fair labor practices as protected by Section 23. So what it is was once again invoking the agreement and saying that the agreement is protected by Section 23. So we respectfully submit then, to sum up, that there is no conflict between the LRA and Regulation 78 and 79, which would enable anyone to trump the explicit financially protective measures in Regulation 78 and 79. Now, may I then move on to deal with a few last points which have been raised by our learned friends or emerged in the debate. The first deals with the point of clauses 3.1 and 3.2 and the problem raised by Justice Theron. we would invite you to look specifically at the order which was made in the LAC. And I believe my learned friend may already have made this point, but if he has, then I apologize for repeating it. It's a 6. And you will see that there is a declaration of unlawfulness of clause 3.3 of the resolution. Now, it may well be, and it would seem to be implicit in the logic which has been debated, that clauses 3.1 and 3.2 suffer from exactly the same problem. But the court would often be acquainted with a situation where a party may deliberately, in litigation, target a particular provision or set of facts or a particular year, say, for example, of a lease renewal or of a license, and seek invalidity in relation to that. It does not mean that the court is bound to go beyond the relief sought by us, or apart from the moment of, I was about to say forensic recklessness, but of ambition, where Justice Madlanga presiding cautioned one of our colleagues for be careful what you ask. But the other side also doesn't ask that 3.1 and 3.2 be declared unlawful. It may well be that what they will represent on the reasoning of the court, if we are correct, is historical curiosities. But nobody asks for relief in that regard. And as Justice Turon was given the assurance by the department, and we give it on behalf of Treasury, there is no intention or ambition to claw back anything that is water under the bridge. The attempt to launch some condictio in debiti would speedily run onto the rocks, and as the court may infer, would be, let us put it, socially problematical. So we respectfully submit that the problem on analysis does not arise, and the attempt, particularly by the PSA, as it were, by saying, well, if you declare 3.3 invalid, you are automatically or declaring 3.1 and 3.2 invalid. Nobody has asked for that. No such order has been made, and we would respectfully submit no such order is given. May I lastly touch on the issue of delay. The position as regards the Ministry of Finance, I've already slightly anticipated, and it is this. The last negotiations which were taking place between the unions and the department took place on the 25th of March last year, 2020. And that, I think, you find in Record Volume 1, page 168 to 171, paragraphs 112 to 113. There were those arduous attempts, which Mr. Brainders has eloquently described, to reach some kind of middle ground. And it's the classic problem which, justices, you would have had to deal with so often in litigation, where parties are trying to resolve something, so they do not go immediately to court and seek to annul. And then later, of course, the problem arises of delay, and the court will call them to account, as this court has called government to account here. As regards Treasury, its position was that it then was joined as a party in the proceedings, not in the court below, but below that, in the bargaining council, and there were interlocutory urgent scuffles in the labor court itself. And that was in the earlier part of last year, so it was after the negotiations.
Mr. Gaunt, sorry to interrupt you, Mr. Gaunt, but Justice Madlanga, we seem to have lost connection with Justice Madondo.
You're muted, Justice Madlanga. Justice
Oh,
Mandela.
I'm sorry. Thank you. Let us continue, colleagues. Let us continue, colleagues.
Thank you. I'm nearly concluded. The points I wanted to make on delay was this. Treasury has its particular role, which I've already addressed. It came in when when it was joined as a party in those proceedings, the rushed proceedings, and in the end, through the cooperation and good sense of all, we were able to consolidate them at first instance in front of the LAC. Treasury, on the 17th of July, filed its counter application, seeking, to the extent it was necessary, the nullification of clause 3.3. So that was, as between the end of the last attempts to resolve the matter on the 25th of March, it was a matter of 3-4 months later, which was certainly not preceded by inactivity, but by limbering up for the litigation. Lastly, on this, in our heads of argument, or I think it's 418? Sorry, Justices, what is 418? Yeah. In our footnote, sorry, I've lost sight of I have it as 418, footnote 416, I think is wrong. Buffalo City. It's in our heads of argument. I'll give you the reference in a moment, but shortly put, it's this. In Buffalo City, this court held that even in circumstances where delay is thought to be unreasonable, given what's at stake, given the public interest, it may overlook it. We submit this vicariously, as it were, about the department. It did not act unreasonably. It was trying, as you've seen, through a series of engagements to resolve the matter with the unions. That didn't come to fruition. Litigation followed, and then the necessity to deal with clause 3.3 arose. Yes, it's on page 48 of our heads of argument for Minister of Finance, in footnote 216, where we refer to Buffalo City and discuss its application in these circumstances. So we respectfully submit that the correct answer to be given to the case is that the Labour Appeal Court was correct in holding, on the principle of legality as a matter of law, that the agreement in respect of clause 3.3 conflicted with regulations 78 and 79. The arguments you've heard today have, with respect, been faint in opposition. Secondly, if they did, then the consequences of the in-principle consequences of invalidity would arise. Thirdly, you would, in the circumstances of the matter, we respectfully submit, not use section 172(1)(b), nonetheless to grant the effects of validity. The justness and equitability is highlighted by the fact that, as has been indicated, for a period of years, there has been the advantage arising for the beneficiaries from this non-compliance with law. Secondly, as has been pointed out, it is only the increment. And although we respectfully are aware that the fact that the increment may mean a lot to those who were involved, but that the increment, which is not forthcoming. But lastly, Justices, and may I make this plain on behalf of Treasury, we don't plead impossibility. We don't plead unaffordability. Whatever you order will have to be done. If you order that the agreement effectively were to continue, then of course Treasury would move to comply. How would it do that? It would have to seek, firstly, to implement measures to borrow money internationally, if it could, for this unpromising project of a historical increment for employees. It could notionally impose a special tax. It could, and this is what it would have to do in any of the circumstances, it would have to rob Peter to pay Paul. It would have to go to those other departmental budgets and see where money could be taken away from departments which have already been stripped. And the terms of 78 and 79, as you know, highlight that as being a first call in the circumstances. So we respectfully submit that there would be little justice or equity in a result which would involve that. And lastly, Treasury could, of course, simply print money or see to it that money is printed. But we all know what a social catastrophe that sets in train, and it offers no just and equitable solution. We would accordingly, lastly, may I just say that as regards the remedy, nothing is pleaded and nothing is shown to show that the Labour Appeal Court did not exercise the discretion it had in relation to remedy in a way which did not accord with principle or was on incorrect facts. So we accordingly ask that the application for leave to appeal not be allowed, alternatively that the appeal be dismissed.
Mr.
Thank you, Justices.
Mr. Gauntlet.
Yes, Justice.
Mr. Mokara says that the matter is not moved because the performance asked for in this matter is a monetary obligation. What is your response to that?
Justices, you would have heard that although in our heads of argument there was a reference to mootness, in our answering affidavit, not our heads, there was a reference to mootness, and Justice Turon has picked up on this. We present no argument in relation to mootness. We submit that the matter is rather to be dealt with on the simple basis of the principle of legality, the conflict, and the consequence which should arise from it. We do not argue before you that the whole matter is moot.
Thank you, Mr. Gauntlet.
Colleagues, may we adjourn for 5 minutes? Let us court adjourn.
Court pleases.
Relation
May I, in the meantime, find out if it's not you, Justice Madondo, that's connected to a device that earlier said Philip's iPhone and which now says Philip Masilo. Is that not you, Justice Madondo?
Judge, I think it's one of the instructing attorneys, not Judge.
It popped up. Yeah. It popped up. It popped up on my screen. Thank you, Mr. Conlet. It popped up on my screen. We had lost Justice Madondo. Oh, I was quite hopeful. It looks like we've lost Justice Madondo. Mr. Conlet, I thought you were done. Mr. Mkari?
Yes. Thank you, Justice Madlanga and Justices. I'm going to reply briefly. Let me first start by clarifying the issue regarding whether it is the entire collective agreement or clause 3.3 of the collective agreement which is implicated in this appeal or leave to appeal. The answer lies in the order that was given by the LAC at page 1596 of volume 16, having regard to the judgment of the LAC, paragraph 50 before the order and paragraph 51. So it is clear that whilst the DPSA in its counter application sought relief in respect of the invalidity of the collective agreement, National Treasury or Minister of Finance's counter application was only limited to an attack on clause 3.3. And the LAC upheld the argument of National Treasury in that the order granted paragraph 51 reads as follows: says it is declared that the enforcement of clause 3.3 of resolution 1 of 2018 is unlawful for contravention of sections 213 and 215 of the Constitution and regulations 78 and 79 of the Public Service Regulations. So that is the order that was granted by the LAC. And if you look at the preceding paragraph 50, where the court concluded by saying the following: the counter applications are, as indicated earlier, inextricably linked to the application once it is found that clause 3.3 of resolution 1 of 2018 infringed the mandatory legal requirements governing the conclusion of the collective agreement by government. It follows that there is no need to deal with the application. It stands to be dismissed in that there is no valid agreement upon which to base applicant's claim, given the nature of this dispute and the legal questions raised. It will be inappropriate to make an order as to cost. So the LAC, after considering the entire collective agreement, it found that, well, not the entire agreement, because the application before the Labour Court, and which landed at the LAC, was concerned with the enforcement of clause 3.3 of the collective agreement. So then I'm simply saying that the debate about whether it is the entire collective agreement or whether it is clause 3.3 really then is immaterial, because there is no cross appeal by anybody to say that the entire agreement should be declared invalid. So the court here is only concerned with clause 3.3 of the agreement. Regarding then the issue of the delay and whether anything should be made out of that, our submission is that the delay should be considered in the context of the appropriate remedy under section 172(1)(b), together with bad faith. The submission by DPSA is that there was no bad faith, and also National Treasury seemed to suggest the same, but we submit that all what the court has to look at is on objective facts, whether there was any bad faith on the part of government. And we submit that on objective facts, this court will find that there was bad faith. And where does it come from? From the government persistently giving unions the impression that it will comply with the agreement when it knew that at the time when it files an answering affidavit, it will raise the argument of invalidity as a defense, and it will also file a counterclaim. May I refer the court to volume 17, page 1665. It is a letter from DPSA. The importance of this letter is the date on which it was written. The court will see that in this letter, addressed to the Public Servants Association, it's a very short letter, if I can read it. Your letter received by email 1 April 2020, addressed to the Minister of Public Service and Administration is hereby acknowledged. We wish to reiterate that the employer is fully committed to the implementation of PSC-BC Resolution 1 of 2018. And then the letter refers also to the proposal that was tabled on 25 March 2020 at the council. This letter is dated the 9th of April 2020. And that at that time, already the last financial year to trigger the implementation of clause 3.3 had already commenced. So even during the financial year for the implementation of clause 3.3, government was still saying to the union, we're committed to implementing the resolution. And it becomes bad faith when the same government, which in April has said to the unions that we're committed to implementing the resolution, to come later and say that this is invalid, and in any event, this is a legal point, it can be raised at any time. We're not taking any issue, don't quibble with that. We know that the legal issue can be taken at any stage of the proceedings or any time when one receives legal advice. But what we do know is that from the government side, it always committed itself to implementing the resolution. And that impacts directly justices to an appropriate remedy. And that's why we've submitted earlier that this case falls squarely within the confines of Gijima, where this court will then say that whilst section 172(1)(a) obliges us to declare the contract or agreement invalid, but we're not going to divest the Gijima of the rights that have accrued to it as a result of the very same invalid contract. And we're saying that this court should do the same in this case, that whilst it may find that the clause 3.3 is invalid, but it should say that because of the conduct of the government, it should not divest the rights and entitlement that arose and accrued to the members of the unions and employees of government from the conditions of service that are beneficial to them by way of increments. So the court is still at large to say that the government must comply with clause 3.3 despite its invalidity because it does not set it aside. And the court can even say, as it was suggested by one of the justices when engaging with me initially, to refer the matter then back to the Public Service Bargaining Council for the parties then to negotiate on how to give effect to clause 3.3. So that will be just and equitable justices, given the fact that we're dealing with the employees of government who could not negotiate for themselves, but entrusted the unions to do so on their behalf because of the scheme of the Labor Relations Act, which does not allow individual employees to negotiate on themselves, but to elect to be negotiated by their respective unions, and who were informed that an agreement has been sealed with the state as employer and that they will be receiving increments over a period of 3 years. So the terms and conditions of employment have then vested within their employment contracts, and it will be unfair to say that those terms should simply be taken away from them just like that when they've actually given them the benefit of a financial nature. So we submit that an appropriate remedy in this instance is one which should not simply allow the government to walk away scot-free and not pay any increment to the employees. So bad faith, we submit that it is objectively determinable. It's not subjective, and we say that just on the conduct that is displayed by the papers of the state, it should be found that the state acted in bad faith. Actually, The minute of 25 March.
The 10 minutes is up, Mr. Mukari.
Okay, let me just wrap up in 1 minute. Just then, as a parting shot, to tie up the letter that I've referred to in volume 15, the one that I've read out from the state, it is the minutes of council of, I think it's 25 March. That, Justices, you'll find it in volume 8, page 70. The minute starts at page 703, is the minutes of the PSCBC Special Council meeting of 25 March 2020, but the relevant passage, you'll find it at page 708, where then the employer put its proposal consistent with what it said in the subsequent letter that I've read of 9 April 2020. So we submit then, Justices, that even if this court may find that regulations 78 and 79 were breached for non-compliance with the a requirement that a written commitment should be provided by National Treasury in respect of the implementation of clause 3.3, it should still not divest the rights that and the entitlement that have accrued to the employees and take into account the delay. We submit that the appeal or leave to appeal should be granted and the appeal should be upheld. And of course, on the remedy, we'll leave it large with the discretion of this court to exercise as the court pleases. Then finally, I'm referred to, I know that Justice Chike was asked questions about whether Section 23 has been alleged by the parties. I'm just going to refer to the pages in respect of the papers of Nehau. That was squarely pleaded in the answering affidavit of Nehau, volume 15. It will be page 1503, paragraphs 21, 22, and 23. Thank you for the indulgence, Justice Madlanga, and to all the justices. Thank you. Those will be our submissions. You're on mute, Justice Madlanga.
Thank you, sorry. Oh, thank you very much, Mr. Mukari. But you may have to come back. I want to minimize a possible need for Justice Madondo to do what I said a justice who loses connectivity may ask us as a court to do, which is to send out directions to raise issues arising from when the justice had lost connectivity. He lost connectivity during Mr. Contlet's submissions. My brother, Justice Madondo, I just wanted to find out if you have any questions you want to put to Mr. Contlet, so that I may interpose him at this stage, so that if Mr. Mukari wants to respond to Mr. Contlet's answers, he does that immediately, and then his other colleagues for the unions follow him.
Yes, I do.
Yes, yes, my brother.
As a court pleases, so then I will then.
You may disappear for a few minutes. Yes, Mr.
Thank you very much, Justice.
Yes, thank you very much, Justice. Mr. Contlet. Oh, thank you. Oh, thank you.
Yes. Yes. Mr. Oh, sorry. Mr. Contlet. Oh, sorry. Mr. Contlet. I lost you when you called to clause 3.3. Because I'm very interested to know why is it isolated from the rest of the agreement.
Justice, essentially on a basis, I suppose, of common sense and practicality and principle, and that was this, that it was accepted that as regards what had been paid pursuant to 3.1 and 3.2, it was water under the bridge. To recover anything in that regard would require an enrichment action against many thousands of people. it would have been argued itself to be unjust, and it was thought in the circumstances not to be pursued. It's not a matter further ventilated on the papers. Justice Madondo, I see you as frozen. I'm not sure if I'm being heard.
You. Let's continue all the way to the end, colleagues. Thank you, Mr. Gauntlet. Mr. Maneche?
Justice.
Please continue, Mr. Gauntlet. Please continue.
Because it just froze.
Yes. Might I ask Justice Madondo whether you were able to hear me, though?
Yeah, I hear you now, but at that time it just froze. I couldn't hear what you were saying.
I see. Yes, Justice Madondo, it's essentially this, that what had transpired pursuant to 3.1 and 3.2 was water under the bridge. To seek to recover from those concerned would be an enormously difficult exercise. It would raise issues of inequity in doing so, and so it was not pursued. What Treasury was simply seeking to do, having been alerted to the problem, was to prevent, as it were, the implementation of further non-compliance with regulations 78 and 79. It's never been suggested on the papers that there is a lack of severability, as it were, in its stance. And it was effectively then the election of Treasury to say that what we are seeking to do is to shut the stable door. Two of the horses have left, but there is one left, and we seek to prevent that because particularly in the circumstances we are now, it is a national crisis. So it is an entirely lawful decision we respectfully submit on behalf of Treasury to say that in the circumstances we pursue only 3.3 as we have done together with the DPSA. Well, DPSA had a wider attack initially, but the LAC, as you were, I think in your period of your absence, it was clear in its own order, only ordered in relation to 3.3, made no order into 3.1 and 3.2. And in your absence, I think Mr. Makari correctly argued that there's no party before this court cross-appealing that order. So there is no live issue in relation to the question.
Okay, thank you, Mr. Gauntlet. I got the last portion from Kari.
Thank you, Mr. Gauntlet. Thank you, Justice Madondo. Mr. Mukari, do you have any response to this answer?
Yes, thank you, Justice Madlanga. I think the issue should be very clear. In respect of 3.1 and 3.2, DPSA under oath has said that the compensation envelope was 110 billion rands.
I'll give you about 4 minutes.
Yes, indeed. Thank you very much. The compensation envelope is 110 billion rands. The compensation envelope was exceeded by, initially it was 30.2 billion, then it was 37.8 billion, and now understand it was by 29 billion rands. But that was in respect of the third and final year. So an agreement of this nature is one that is perfectly severable because you cannot lump the 3 years together because government always then budget on the basis of its financial year. And DPSA tells the court and everybody that in respect of the first 2 years, that was covered by 110 billion rands. Therefore, Regulation 79 was not implicated, because Regulation 79 only becomes implicated when the compensation envelope is going to exceed. Actually, it simply says that where there are financial implications and there is no money from that department, National Treasury must cover for the rest. So the rest is in respect of the third year. And that's really what we're dealing with. And that's exactly what the LAC concerned itself about. So I'm simply making it clear that there was no issue about the legality of 3.1 or 3.2. And the impression must not be created that government is simply giving the employees freebies because then it is sympathetic to them that they've taken money unlawfully under 3.1 and 3.2. The 3.1, 3.2 money was paid lawfully to them. And what is being debated is whether are they entitled lawfully to be paid 3.3. So those are submissions. And thank you very much, Justice, the Madlanga and the Justices.
Thank you, Mr. Mkari. Mr. Maineche?
Thank you, Justice Madlanga. I propose to address a few matters under compliance, delay, the offer that was made at council, and the question of remedy. On the question of compliance, during the debate, there seemed to have been a submission made by our learned friend for the DPSA that the cost-cutting measures were intended to keep the collective agreement within the ceiling of the envelope that was approved. In other words, to bring it within 110 billion rand. That is not consistent with the evidence from the Minister of Public Service and Administration, because the minister makes it clear that the cost-cutting measures were intended to cover the excess, in other words, the 30.2 billion rand, and that was the purpose of the National Treasury's presentation on the 2nd of May 2018, was in relation to that excess. And you will find that explanation in the DPSA's affidavit in volume 2 at page 147, from paragraphs 76 to paragraph 80, where it's made clear that the cost-cutting measures were intended to cover the amount by which the collective agreement exceeded the compensation envelope as approved. And it says also in those paragraphs, especially paragraph 77, that this was on the advice of National Treasury. And that refers to the presentation in volume 4, which the court finds at 315. And now in that—
Sorry, Mr. Minechi, why is your explanation inconsistent with the submission by Mr. Branders that the cost cutting was intended to bring the offer within the envelope of 110 billion? That's the same way of saying that the cost cutting was intended to cover the Rand 30.2 billion excess.
I accept that that's another way of looking at it. Another way, what Justice Rogers is saying is, if the 110 billion plus 30.2 billion rand brought the amount outside of Regulation 79, the cost-cutting measures were intended to make it compliant. In other words,
yes,
there will be the approved budget of 110 billion rand plus the 30.2 billion rand, which will be covered from the monies released from the cost-cutting measures, the implementation of cost-cutting measures. I think to that extent, Justice Rogers is quite right. I just thought that there might be the understanding that the 110 required cost-cutting measures to be met. And that is what I was clarifying. And on that, Justice Rogers again raised the question that this was almost like a wishful thinking on the part of government. But in fact, when one has regards to the National Treasury's presentation in volume 4, and including at page 340, 341 to 343, you will see that estimates were worked up as to what the cost-cutting measures might yield. And the estimate at page 340 was that you could raise up to 40 billion rand if about million heads were cut off, so to speak. You'll see the employee initiate several packages, and it estimates what amounts could be recovered under those scenarios. All I'm suggesting is that National Treasury did some work to come up with a presentation. It's not as if it was just, well, see what you can do. And that continues at 342, and you will see at 343, the last bullet makes it very clear that the DPSA would need to lead government in implementing the program to ensure that it is successful. And then the actual recommendations come at page 350, that the Committee of Ministers is requested to approve the following. First bullet, upscaling of implementation of the EASP, coordinated and funded from the center by the DPSA and National Treasury respectively. Treasury would approach the GEPF to initiate engagements on funding the penalties associated with early retirement, and it would develop a repayment program spanning a mutually agreeable time. The immediate costs associated with implementing an EISP program are funded through the budget process. All relevant matters relating to cost-cutting, cost-saving initiatives to be tabled for discussion at the upcoming 2018 MTEC engagements. Tabling of employer-initiated severance package to flow for central identification of specific cases to be exited and minimize adverse impact on service delivery. And then you talk about, they talk about the implementation of short-term, medium-term programs. And that is what government, the ministers agreed to be the mandate, which was then taken to the unions. And quite rightly, that mandate, which is 16.1 that was referred to during the debate, which has the footnote about the conditionality, that was not placed, the actual mandate was not placed before the unions, and the affidavit of Satu makes that clear. And so what remains is that it is the failure of government to implement the cost-cutting measures which, on the strength of which it presented an offer to the unions, which results in the position in which we are. And even Minister Nene's letter, which is in volume 10, and is dated 11 July 2018, so after the conclusion of the collective agreement, you will see that it doesn't say that the collective agreement is invalid. What it says is that it exceeds the compensation envelope, but there are cost-cutting measures to be implemented in order to comply. And at 944 in that volume, again, there is a further reference to what must be done in order to cover the shortfall of 30 billion rand and numbers of employees that must exit, about 20,000, I said 20 million, I think, 20,000 employees. So this is the strength on which the employer made the proposal, and it's the employer that controls the implementation of cost-cutting measures and asking for employees to exit the public service. And they made that offer. And I say again, and the government did not contradict this, none of my Nelen friends, that if they had successfully implemented these measures, even after the letter of Minister Nene, they would not be here complaining that this agreement is invalid. They would be saying, as National Treasury says in its answering affidavit in this court, that the relevant funds will be released through the normal budget process to cover the shortfall. So the argument of invalidity is when it is faced with the question of affordability. And that is why even at the bargaining council in 2020, in March and February, the issue of invalidity is not raised. Minister Nene doesn't raise it, nor does the letter from the Director General responding to the PSA making a demand in March of 2020 is the issue of invalidity raised. This issue is raised backwards, and that is why you get the argument that this is a matter of strict compliance. Because if you're looking at purpose, which is correct, my learned friend Mr. Gauntlet is correct, you look at whether the purpose of the provision would have been fulfilled. Now, it's clear that if the cost-cutting measures were successfully implemented, the purpose of Regulation 79 would have been fulfilled, and there would be no question of invalidity. And so this whole case is about affordability, which has morphed into an invalidity issue. And that's why the Minister of DPSA, in his replying affidavit that I referred the court to, was clear that there was no non-compliance. What happened was the measures were not successfully implemented, and that's the government's problem. Now, on the question of delay, our learned friend, Mr. Gauntlet, says Treasury doesn't have the same problem as the DPSA. But if he is correct, then when Minister Nene sent out that letter, it was clear then that there was non-compliance. But they waited this long to bring the application. Anyway, they are the ones that pay. They release the funds. How could they not have realized? We know from the NT's own presentation, the National Treasury's presentation, that they were aware that there would be an excess amount here. So it's not an excuse for them to wait for March and then to say they only delayed from March to now.
The 10 minutes is up, Mr.
Just two issues, and I'll be very quick.
How much time?
The last issue is a question of...
How much time?
I think 2 or 3 minutes I should be done. Yes, the second last issue is the question that has been raised repeatedly. Mr. Brander said, we've tried our best to make it work differently, and they have refused. I refer the court to page 174, paragraph 133 of the DPSA's answering affidavit in volume 2. You'll see that that amount of 10 billion rand that was reprioritized from salary progression was made clear that it is not going to be a salary increase. It is a once-off payment. So it's like a bonus once-off payment, but doesn't add to your salary increase. So it was a different offer completely. It wasn't to implement regulation, clause 3.3 differently. The last point is about remedy. Our learned friend, Mr. Brander, says SATU and the other unions only raised just an equitable remedy in argument at the Labour Appeal Court. That's not correct. You will find it in volume 12, which is SATU's answering affidavit at page 1243, that in fact, SATU asked for a staggered or a phased-in implementation of clause 3.3. And all it has done in addition, in argument before the LAC, and does so in affidavits and in the notice of motion, is to ask that that be dealt with through negotiations at the Bargaining Council. And this court has said repeatedly that fashioning a just and equitable remedy is not constrained by what parties ask in notices of motion, but is there in the affidavit. Is not correct. Our learned friend, Mr. Brainders, is not correct that it was only raised in argument. So we submit with respect that there has been substantial compliance. If that is old language, there has been compliance which would have met the purpose of Regulation 79 in terms of the old pay judgment, and there is no reason to uphold the declaration of invalidity. And we ask for relief in terms of the notice of motion, as the court pleases.
Thank you, Mr. Maineche. Ms. Moore.
Justice Madlanga, Justices, I have 4 bullet points in reply, and there will be bullets. We have sought an order that should the court find the conduct of the state to have been unlawful in concluding the agreement, we have sought an order that the relevant ministers must report to Parliament in terms of Section 16A of the Public Service Act to explain why so much unlawful, to use Mr. Gauntlet's words, so much unlawful water has flowed under such a large unlawful bridge by the implementation of the first 2 years of this collective agreement. I was waiting to hear from the Council for the 2 ministers whether there was any, we're going to deal with the issue at all. They haven't dealt with it. It seems to me it must follow a finding of unlawfulness by this court that report should take place. Bullet 2. My clients were deprived of the right to strike by the conclusion of this agreement. They had every intention of striking because they didn't agree with the content of the agreement. That right is deprived if the court finds that the agreement was unlawful, then that right has been taken away from them by the unlawful conduct of the state. The only way to give some content back to them of that right is to declare the entire agreement invalid, so that at least at the notional level, they could consider whether they would now want to strike about the agreement as it was concluded 3 years ago. There's no other way to give them anything approaching the loss of their right other than the declaration of invalidity of the whole agreement. Bullet 3. My learned friend, Mr. Gauntlet, has raised a number of ways of which he says the state would comply if an order was made, printing of money, etc., etc. There's a much more sensible way by which the state could comply with the order, despite their financial straits, and that is to implement the cost-saving measures that they should have done in the first place. And that may possibly include the opening of retrenchment consultations, and it may include tabling as an alternative to retrenchment, a renegotiation of clause 3.3. That is the collective bargaining solution to the problem that the state finds themselves in. That's what anybody in the private sector would have to do. Bullet 4, and this relates to the questions raised by Justice Triki on several occasions about the trumping clause in the LRA. The trumping clause does apply. The LRA in sections 23 and following, that chapter of the LRA, sets out the requirements for various types of collective agreements and for them to be valid. The basic one just needs to be in writing between a union and an employer, etc., etc. Then there are the special collective agreements, the agency shop agreements, and the closed shop agreements. The effect of a finding that 78 and 79 must be read in as an extra is a trumping. It's saying, the LRA says, if these are complied with, a collective agreement is binding. But the state is now saying, no, in this case, there's an extra here. And so we say the trumping provisions do come into play. Those are our 4 bullet points, Justice Madlanga, and we obviously persist with our request for relief as set out in the notice of motion.
Thank you, Mr. Orr. Mr. Van Wyk.
Thank you, Justice Madlanga. I have nothing to add to what has already been said by my learned colleagues for the other applicants. Especially the PSA, we share the same position.
Thank you, Mr. Van Wyk. And thank you to all counsel. Judgment is reserved. Court adjourned.
As the court pleases. As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.